Здравствуйте, уважаемые коллеги.
Good morning, dear colleagues. We are continuing our conference. Let us commence our activities in the section that's entitled International Justice, Challenges and Tendencies. The first person to take the floor would be Mr. Dedov. He's the judge of the European Court on Human Rights. He'll be talking about independence and impartiality of judges on human rights.
Dmitry Ivanovich.
Good morning, respected Mr. Dedov. I'm pleased to see and hear you. Very good morning. So pleased to thank you very much indeed for inviting me to take part in the conference. So we'll be pleased to hear you. Look, last time I was unable to travel, irrespective of the circumstances they were part of my control. These days it's online, and I believe it's not bad, at least quite good. It does not prevent us from communication, and to some extent it facilitates the opportunity to get together and discuss certain important things. Say, from the point of view of the trends, I would like to touch the issue that is related to independence and impartiality of International Court, taken as European Court on Human Rights example. A lot is being done to achieve this. At the same time, there's a lot of challenges arising, where we have to answer these challenges, or meet these challenges, face these challenges. The general structure of ensuring independence, general requirements, well, first of all, they are related to the procedure of selection of the election of the judge. And this procedure, I would say, is kind of ideal, which offers three, at least, alternative candidates to choose from. They have to be equal. Again, based only on the alternative approach, the voting takes place. And this would be at the level of the parliamentary body that Parliamentary Assembly of the Council of Europe would vote or decide. However, irrespective of this kind of harmonious procedure, a lot of criticism is heard in relation to quality of election. Selection and election do exist. For example, if we speak about the practice in this field, practical experience in the sphere of protection of human rights, there are voices heard saying that you have to take from the sphere of legal defenders, human rights defenders. I don't think it's the right approach to understand the role of the judge, because the judge is not the one who protects rights. Well, definitely he or she would protect rights, defend rights, he or she would look into a specific case, but not necessarily takes a decision into favor of the claimant. Well, sometimes in favor of the state, provided the actions of the state were compliant with the standards and requirements that the court and other bodies developed, or the communities they developed. In interaction with other bodies of the community, it's also an important element, and it embodies that the court uses the material of the Venice Commission and the Committee of the Ministers, recommendation of Committee of Ministers, and other documents approved by the Parliamentary Assembly of the Council of Europe, and then recommendations as well, in addition to different conventions, which are part of the structure of international protection within the framework of activities of the Council of Europe. However, there are plenty of challenges to meet, to face, So a certain period of time ago, there were accusations or allegations and criticism from many states that the court takes decisions sometimes that are difficult to predict, and the policies aimed at support of the so-called activists. These allegations and accusations were voiced by the politicians, members of the parliaments, and the judges of the national courts. First of all, the judges of the Supreme Court of the UK, High Court of the UK. So a lot was written about it. Major legal issue that has been arising in this respect was related to the fact to what extent the compulsory nature of the provisions of the conventions are. I mean the European Convention on Protection of Fundamental Rights and Freedoms of Humans. So to what extent they're compulsory, or they're kind of concept which is necessary to apply not in a very strict manner, but of the nature of kind of recommendations and the kind of concepts. Well, a lot of opinions were expressed, and this kind of criticism was expressed, was voiced, so that the court reacted, and they seem to have found an opportunity to mitigate, soften this criticism. At present, there's a trend so that decisions and verdicts are better justified, better weighted, better balanced, better, more neutral. Certainly there are cases when some mistakes occur of the political nature. For example, in the case Mammadov against Azerbaijan, or versus Azerbaijan, when the Committee of Ministers complained that Azerbaijan failed to implement the decisions of the European Court. The court was forced to consider and evaluate, in this case, the actions of the state related to implementation or execution of the decision or verdict of the European Court. Well, I have to say that one of the serious challenges for the European Court and for our time in general, there's a kind of risk. There's opposition that cannot be accepted. So between liberal values and traditional national values, sometimes I would refer them as conservative values. In this respect, this opposition of interests results in accusation of one side being populist, well, from the other hand, judges may suffer of the national, constitutional and higher Supreme Courts, and so there are persecutions occurring in countries like Hungary, Poland, in Turkey, so judges are being persecuted. No doubt this is not a good sign, and in this kind of conditions of opposition, certainly it's very difficult to conduct activities of the court, while at the same time the court finds an opportunity to adopt unbiased decisions. The secret of success in this kind of uneasy conditions is in considering of all circumstances of this particular case, elaborate specific, clear and unbiased criteria where the court itself takes decisions in relation to specific cases and gives recommendations to national courts the way they should consider which factors they have to take into account, so that they consider the case in appropriate way. Say the mistakes made or criticism of liberal approach is So, in inverted commas, when we say liberal judges or people that take this kind of decisions, they put as very important, as a priority, they consider general freedoms in their absolute perception or understanding, irrespective of other circumstances and interests of third parties that can be touched by this kind of actions, and the interests that are in conflict with this kind of rights and freedoms. For example, let's take the problem of the practice of the court. So this was related to the issues like relation between, or ratio between the right to express the opinion and the form of expression of this opinion that might diminish the interests of democracy, thus be incompatible with values of democracy. Well, not necessarily the right decision, the right solution is found. Fernandez Martinez case, for example, even if the court uses general methodology, so that the tests for the proportionality, certain principles related to protection of procedural right within the framework of the rule of law, not necessarily they find this kind of compromise approach and this is decisions, so they compare the circumstances and sometimes they compare the values that are incomparable. Fernandez Martinez case was comparison of values related to loyalty to religious organization and the right to create a family and so on. Well, it seems to me there are incompatible values. Well, coming back, I'm coming back Mammadov against Azerbaijan case. This was related to criminal persecution in relation to opposition blogger, journalist, that was supposed to tell true stories. Well, he was convicted. A committee of ministers in that particular case demanded that Mammadov is freed, but at that time, in relation to this Mammadov, there was a decision of the court that the limitation of his freedom, or deprivation of freedom, his arrest, was not related to violation of Article 5 of the Convention. But the time the Committee of Ministers demanded immediate freeing of Mammadov, hearing of the criminal case was conducted and the verdict was adopted, the decision was taken, so the verdict was brought against Mammadov. The situation changed completely by the moment of time. This case was extremely difficult for the European Court of Justice, for the European Court of Human Rights, because they were forced to consider the case in the dynamics. In the course of hearing, in the course of consideration, Azerbaijan freed Mammadov. In general, they complied with the requirements. At the same time, they did not relieve him from criminal liability. At the same time, they allowed reconsideration, at least formally reconsidered the case, without taking into consideration the circumstances that they were referred by the European Court of Human Rights. So, in fact, there was no opportunity offered to the claimant so that the claimant and the consideration of the case is having no defects or no limitations that would create an obstacle, that in relation to him fair administration of justice was conducted or was taking place. Well, as you know, both parties were wrong, were not, at least not right, and they were making violations So the small circumstance allowed the judges that were doubtful, allowed them to join the majority and find violations in the case because the claimant, in the long run, was not offered procedural guarantees enough to protect his interests in the criminal process. Well, basically, this kind of trends and challenges I would like to point at that exist, and then as we see them from Strasbourg. Thank you. Thank you for your interesting presentation. The issues that you referred to, the questions that you've been raising, they are important for all judicial systems, for all courts, and then these problems do exist here in these countries. We also consider the decisions that can be predicted or should be predicted, the issue of execution or implementation of decisions. So a number of times we have been facing the problem, but I liked very much your wording of success, secret of success in the decision taking is unbiased and thorough consideration of all circumstances of the case, elaboration of clear-cut criteria, and the most important recommendations. I like it very much, I say again. And frankly speaking, in our everyday work, we do our best. Well, we cannot judge ourselves, but we do our best to follow this kind of secret. In any case, again, thank you very much indeed. And I believe this was a very interesting meeting we're having. All the best to you. And I hope after pandemic is over, we will meet on a more frequent basis. Well, certainly, I agree. Thank you. Well, I would be happy to listen to you, to your presentation. Well, I'm not going to insist that the very truth I'm saying, and certain theoretical judgment, I would be referring to very specific, very practical side of the problem. It seems to me that it arises, even though we don't seem to discuss it in a thorough, detailed manner, but from time to time this issue is being raised.
For this reason, I've entitled my presentation, my talk of the day, the concept of limitation of judicial action, a statute of limitations at the EAEU court, what lessons from practice tell us. I believe that things I'm about to disclose right now, to present right now, is mostly food for thought. It's more like a message going out to the academia members, to the scientists of the Eurasian Economic Commission, saying that, urging them to finally consider this point. The activities of the Court of the Union made it possible to identify some practical nature of issues, some issues of a practical nature, the resolution of which, in my opinion, seems appropriate and urgent, both in order to improve the further functioning of the Court and to strictly observe such a principle of the implementation of legal proceedings enshrined, in particular, in paragraph 53 of the Statute of the Court, as equality parties to the dispute. The implementation of this principle presupposes the parity of the rights and obligations of the parties to the dispute, which means that all parties to the dispute have equal procedural opportunities to exercise and protect their rights and interests. So as to comply with this principle, national legislation and the law of some authoritative organizations that have judicial bodies establishes a number of institutions of substantive law, which include the statute of limitations, which is a period for protection against the claim of a person whose right has been violated. More precisely, the time after which the possibility of exercising the violated right by means of a claim is extinguished. The Institute of Statute of Limitations helps to eliminate uncertainty in the relations between the participants or certain legal relations, in our case the Commission and economic operators. When there is none, or in its absence, the person entitled to go to court may keep the violator of the right under the threat of applying judicial measures for an indefinite period of time, without realizing his interest in protecting the violated right, basically waiving the remedy, without waiving the remedy. In addition, collecting evidence becomes difficult after a long period of time. Thus, the establishment of the limitation period, prompting a party to go to court to protect their rights in due time, simultaneously serves the interests of the other party and the interests of the rule of law as a whole. The conclusion follows naturally. The right to judicial protection cannot be absolute. In order to maintain the balance of the rights of the parties, a system of checks and balances functions, an integral element of which is the institution of statute of limitations. However, this institution is not provided for by the statute and the rules of the Court of the Union, although, as indicated above, it is closely related to the principle of equality or equal footing of the parties to the dispute. This report presents a brief analysis of the problematics. It clearly shows the advisability and feasibility of applying the statute of limitations in disputes based on statements by business operators. As the activity of the court has shown, in some cases the circumstance has an adverse effect on the procedural position of the Commission, which is attracted by the defendant at the request of an economic operator. To date, the Commission as a defendant is not entitled to declare the application of the limitation period by the court, and the court is not entitled to apply it on its own initiative. In practice, this manifests in the fact that in some cases, business operators take a long time to appeal against the decisions of the Commission, adopted way back in 2011-2012, when Eurosec was in full gear, but included in the law of the Union, or the inaction of the EEC, which took place according to the plaintiffs many months ago. The above facts generally disavow the concept of reasonable timeframes and are based on the subjective disagreement of the plaintiff with the action or omission of the EEC, by the EEC. I'd like to showcase this issue by citing the circumstance of the case of TMR Import LLC on the recognition of the EEC decision dated December 2012 as not complying with the agreement. The plaintiff, TMP Import, was registered on January 27, 2015. On October 2015, the customs post of the Domodedovo airport denied the company to release the goods. On March 6, 2017, a year and a half on, the company sent an appeal to the Commission for a pretrial settlement of the dispute. Upon receiving a response from the Commission on May 13, 2017, the company went to the Union Court. Thus, the Commission's decision became the subject for an appeal 4 years after its adoption and 2 years after the alleged violation of the plaintiff's rights. The paradox of the situation lies in the fact that a legal entity created 2 years after the adoption of the EEC decision is endowed with the right to appeal it to the Union Court. In a specific case, this basically means an attempt to revise the Act of Union law due to the subjective disagreements of the plaintiff or claimant. At the same time, the founders of the business operator were obliged to know about the action of the Commission's decision before the establishment of the company. I'll give further examples of the lack of such practice in the EAEU. Another vector of problems of the absence of the institution of limitation of actions in the EAEU is the fact that in a number of cases business entities who believe that the Commission has violated the rights and legitimate interests formally comply with all the requirements of the statute and the regulations. They go through the pre-trial settlement procedure as established by paras 43 and 44 of the statute of the court. However, having obtained a response from the Commission within the prescribed 3-month time frame, they apply to the court after 10 or even more months, which raises questions from the legal standpoint. The position on the establishment in the law of the Union of the institution of the statute of limitations is based on the analysis of case materials. In this regard, I can cite a decision of the court dated March 2020 on the application of Translogistic Consult on challenging the Commission's omission. which convincingly show the advisability of including the Institute of Limitations in the statute of the court with the beginning of the running time after the completion of the pretrial dispute settlement procedure. In September 2018, the company applied to the Commission on the Classification of Goods. 2 weeks on, the EEC sent a response to the claimant, which that claimant regarded as omission. On August 26, 2019, 11 months after the completion of the pretrial settlement procedure, the claimant came to the Union Court with an application for recognition of the Commission's omission as not complying with the Treaty on the Union Court. The question naturally arises about the reasonableness of a period of 11 months for an economic entity to apply to the Union Court. As the practice of international and national courts shows, an economic entity in most cases applies for judicial protection as soon as possible. This circumstance has two reasons: the existence of the statute of limitations per se, and the intention of the subject of the appeal to promptly restore their rights, immediately restore their rights. In this regard, the following examples are indicative. Judgment of the EAEU Court, dated December 2015, in the case of the application of the notoriously known individual entrepreneur K. Tarasik. This individual entrepreneur, in October 2014, in disagreement with the actions of the customs bodies and decisions of the judicial authorities of the Republic of Kazakhstan, appealed to the Commission. Having considered this appeal or application, the Commission, in a letter dated November 2014, informed the entrepreneur that the legal assessment of the legality of the activities and decisions of the customs authorities of the Member States is beyond the competence of the Commission. 10 months on, in September 2015, 10 months after the pre-trial settlement was over, the entrepreneur applied to the Court of the Union again with a statement recognizing contested inaction or omission of the Commission as inconsistent with international treaties within the Union. Judgment of the EAEU Court, dated April 2016, on General Freight, CJSC. Close Joint Stock Company General Freight applied to the EEC on July 6, 2015, demanding to overturn the Commission's decision number 117, dated July 2014. The response of the Commission was received by the applicant within the 3 months time frame. More than 1 year afterwards, in December 2015, more than 1 year after the pretrial settlement was over, the company applied to the Union Court requiring to recognize the Commission's decision on non-compliance with international treaties within the Union void. As can be seen from the above examples, the existence of the statute of limitations and reasonable time limits when applying to the Union Court is an objective necessity. I believe it's advisable to use this institution in two directions. Exclusion of the possibility, or ruling out of the possibility, to appeal against the decisions of the Commission taken before the registration of an economic entity, since the rights and legitimate interests of such entity or person could not a priori have been violated before its creation, and the establishment of a business operator in the already existing legal framework of the Union. This initially means its obligation and consent to operate within the framework of the already established rules. The introduction of a limitation period when applying to the Court of the Union for business operators is impossible. For example, 6 months after the expiration of the 3-month period for pretrial settlement. In continuation of my report, and as an additional justification of the stated position, I believe it necessary to give examples of normative regulation of the institution of limitation in the EU Court, the EFTA Court, the ECHR, in accordance with Article 263, former Article 230 of the Treaty on the Operation of the Union of the European Union, dated March 25th, 1957, as amended and appended in 2007. The Court of Justice of the European Union monitors the legality of legislation, acts of the Council, the Commission, and the European Central Bank, except for recommendations and opinions, as well as acts of the European Parliament and the European Council aimed at creating legal consequences against third parties. In addition, the Court of Justice of the EU monitors the legality of acts of bodies or institutions of the Union aimed at creating legal consequences in relation to third parties. To this end, the Court of Justice of the European Union is empowered to adjudicate on claims brought by a member state, the European Parliament, the Council, or the Commission for the lack of competence, violation of essential procedural requirements, violation of treaties or any rule of law relating to the application or abuse of power. Under similar conditions, the Court of Justice of the European Union is empowered to rule on claims brought by the Court of Accounts, the European Central Bank, and the Committee of the Regions in order to protect their prerogatives. Under the conditions provided for in the first and second paragraphs, any natural person, any individual or legal entity may file claims against acts to which he or she or it is an addressee or which directly and individually affects them, as well as against regulations that directly affect them and do not require enforcement measures. Acts on the creation of bodies and institutions of the Union may provide for special conditions and procedures for claims filed by individuals or legal entities against acts of these bodies or institutions, which are aimed at creating legal consequences against them. The claims provided for in this article must be filed within the 2-month time frame. The countdown starts depending on the case from the moment from the moment the act was published, from the moment the plaintiff was notified thereof, or in the absence of such publication or notification, from the day when the plaintiff learned about such act. The official publication is the official journal of the European Union. According to the rules of procedure of the EU Tribunal of the first instance, due to the remoteness of the person, this period can be extended by 10 days for the purpose of delivering a judicial correspondence, or court-related correspondence. As follows from the provisions of Article 265 of the TFEU Treaty, states in a number of cases have the right to appeal to the EU Court of Justice for the omission of the Union bodies. An application may only be accepted for consideration if the relevant institution, body or institution was first asked to take action. If after a 2-month period from the date of such a proposal, the institution or the body or authority failed to determine their position, the claim may be filed within the next 2-month period. Article 269 says the court is empowered to decide on the legality of an act adopted by the European Council or the Council on the basis of Article 7 of the Treaty on EU, solely at the request of the member state that has been the object of the European Council or Council's determination, and only in relation to compliance with the procedural requirements established by this article. Such an appeal must be submitted within 1 month from the moment of the said statement. The court makes a decision within 1 month from the date of filing the appeal. Similar rules are established in the law of the EFTA, in accordance with Articles 36 and 37 of the agreement between the European Free Trade Association on the establishment of a supervisory authority, similar to the EEC, and the Court of May 1992, any individual or legal entity has the right to appeal to the EFTA Court decisions of the EFTA supervisory authority in relation to this person or entity, or decisions in relation to another person or entity if it directly concerns the first entity or person. Proceedings in this case, or in cases referred to in this article, must be commenced within 2 months of the publication of the measure by the EFTA supervisory authority, or notification to the claimant, or failing that from the date on which claimant became aware, as the case may be. In the event that the EFTA supervisory authority, in violation of this agreement or the provisions of the EEA agreement, fails to take any action, the EFTA member state can file a claim with the EFTA court to establish a violation of the agreement. A claim can only be accepted if the EFTA supervisory authority was to take legally binding action. If within 2 months from the date of the application the EFTA supervisory authority failed to determine its position, the claim may be brought within the next 2 months. In accordance with Article 42 of Protocol 5 to the said agreement, the term for filing claims against the EFTA supervisory authority in a non-contractual liability case shall expire 5 years after the occurrence of the circumstance that gives rise to their presentation. According to paragraph 1, Article 35, Conditions of Admissibility on the Convention for the Protection of Human Rights and Fundamental Freedoms, November 1950, as amended on May 2004, the court may accept a case for consideration only after all domestic remedies have been exhausted, as provided for by the generally recognized norms of international law and within 6 months from the date of the final decision by the national authorities. As follows from these examples, the statute of limitations is applied in all 3 courts of international bodies with a different circle of member states. At the same time, the limitation period does not exceed 6 months. The ECHR plans to cut it down to 4 months instead of 6. Protocol number 15 to the Convention on Human Rights and Fundamental Freedoms. This protocol is yet to enter into force. At the same time, the provision on limiting the time frame for filing a complaint will enter into force simultaneously for all member states of the CE. In conclusion of my report, I believe these conclusions are necessary. The statute of limitation or limitation of actions institution has been established and applied in the practice of judicial authorities of reputable international organizations for years. The practice of the Union Court shows the need for normative consolidation of such institution of the court. The application of the limitation period is one of the important components of the equality of the parties to the principle. So it's possible to include this with the initiative suggestion of the Commission. Thank you very much for your attention. Now I'm switching to my duties as a moderator. Section number 1, International Justice, Challenges and Trends. I would like to give the floor to a renowned expert in our contracts. It's Alexei Spalinov. He'll be talking about the constitutional jurisdiction of international courts, some lessons for the EAEU court.
Good afternoon to all attendees and those present at the conference. I will share very quickly my presentation so that everyone could see my screen. Yes, я нашел уже. So can you see it? Well, it's advisory jurisdiction of international courts, certain lessons for the EAEU courts. So why the topic was selected in this way? I believe that for the court the role of advisory jurisdiction is important. However, until now, it's not appropriately evaluated. So the practice of other courts, of international courts, evidences that advisory jurisdiction can be used to find solution to the different problems as the court of the Union is looking for this problem. So in essence, we could see how the consultative, how advisory jurisdiction are used by the court per se. So general characteristic. So advisory jurisdiction is the preparation by the courts of conclusions on the issue of interpretation or application of international norms, not necessarily independently by following the request of the states or the international organizations or appropriate bodies. The general rule says this kind of opinions of no compulsory nature being an instrument of soft law. So they do not have character of res judicata and do not result in liabilities neither for initiator of the request or for any third parties. Permanent Court of International Justice, which looked at advisory jurisdiction as well as International Court of the UN, permanently underlined the nature of the advisory jurisdiction, which is not compulsory. However, one could immediately say that take into account that the advisory jurisdiction is actively used by a number of international courts, this kind of legal acts has a lot of advantages that cannot be disputed. Because advisory jurisdiction, in its essence, is less confrontational compared to the decisions on the core disputes, where the state that is losing, or the side that is losing, that could express its discontent, unwillingness, openly failing to implement. Judges argues about the legitimate nature of the. So it's not limited by the facts and evidences of the dispute. So there's limitation. And according to the jurisdiction, scope of competence in considering the case, exactly the freedom and absence of the confrontation that is allows the court that is formulating its conclusion, opinion, to be free in considering the provisions of the law. Sometimes they're offering revolutionary concepts, and then very often, as the Court of the European Union practice, international court, sometimes they reword or reformulate the request itself, preparing the ground to give answers, provide answers, so that the international court considers this. When we speak about the role of advisory jurisdiction, and everybody is aware, some of the advisory opinions, jurisdiction were of the revolutionary nature, impacted considerably development of international law. Suffice it to mention the two advisory jurisdictions that were taken very early. So this, the reparation case of the UN, one of the first. It was admitted as doctrine, so the legitimate nature of this kind of decisions. And the second consultative reservation case was the second one. Then it resulted in change the law of international treaties and agreements. In addition, as practice of the international court's evidences, advisory jurisdiction is very actively, very often uses as the tool to solve organizational issues of international organizations. For example, 22 out of 28 advisory jurisdictions of the International Court of the UN were dedicated to these issues. Exactly to these issues. In this respect, the court is offering us housekeeping function, so keeping things in order in this international organization. When we speak about instrumental approach using the advisory jurisdiction, the same International Court of the UN, it's not very widely known that they're making use of this advisory jurisdiction. Making use of this, the governments, the states, bypass the lacunas in jurisdiction of this or that international court, of the same International Court of the UN. We are aware that International Court is competent to consider cases between the states only. International organizations are outside of the scope of competence. However, sometimes there are situations when one would like to solve the problem. In this kind of situation, the decision is taken by specific agreements where the opinion of the International Court is of compulsory nature to implement. So we speak about the agreement on placement of the headquarters of international organizations, which take the right, acquire the right, whether they approach or request themselves or via General Assembly to the International Court, obtain the opinion, whereas the agreement to place the headquarters is of compulsory nature. So in fact, we speak about the advisory jurisdiction results in the tool of resolving the dispute. Same is applicable to the Convention of the Privileges and Immunities of International Organizations and other treaties. Very few people know that before the convention entered into effect, Convention of 1986, the Convention, Vienna Convention on the law of international treaties and international organizations, the same mechanism is applied. When we speak about the international treaty is considered void, the same mechanism was offered by the convention when international organization taking part in is a party to the agreement, so either indirectly or via General Assembly to approach for advisory jurisdiction through decision of International Court. Advisory decision is of compulsory nature. Another option is less known situation when the advisory jurisdiction of the UN, of the International Court of the UN, is considered as decision of the quasi-appeal instance. It exists as an opportunity to approach the International Court to receive the jurisdiction based on the following the decision of the Administrative Tribunal of the International Labour Organization. Out of 28 advisory jurisdictions, where 4 were taken as appeal, or at least represented as appeal, because in legal form this was advisory opinion, so it was an appeal against the Administrative Tribunal of the UN, of the International Labour Organization, because the court considered not only, in fact, they considered this, appealed this against. It was pure appeal. In the same kind of appeal instance, one advisory jurisdiction opinion against the decision of the International Tribunal of the ILO. Practice of advisory jurisdiction in the international courts occurs in the International Court of the UN. Statistics, Permanent Chamber of International Justice, within 24 years, 28 advisory opinions. In one case, the Chamber refused to provide opinion. International Court of the UN, much less. If you look at the time from 1946 till 2020, 28 advisory opinions, in one case, refusal to take. Recently, the trend is definitely looking at reduction of this kind of opinions. Much more was in the beginning because they were adjusting the tool. I've spoken about it a little bit, and I would touch it at a later stage. Now it's much less. Another interesting aspect, the initiators of requests in most cases were the General Assembly. In 17 cases, in one case only the Security Council. If we look at the number of advisory opinions in the American Court of Human Rights, 25 advisory opinions. It was interesting to note the wide nature of parties that would request this kind of opinion. It's not only Institute of American States, but the states themselves. As well, the subject of this kind of request could be not only the request to apply or interpret the American Convention of Human Rights, but as well as other covenants on human rights. Say, a pact on human rights, the request could refer to national laws of this or that state, and American Convention and other treaties and covenants related to human rights. Once again, I would reiterate the wide nature, the wide list of persons or parties that could approach with this kind of requests, and wide nature of requests that could become the basis of such requests to receive advisory opinion. In this respect, Inter-American Court on Human Rights takes a unique position. Court of the EU, much less advisory opinions, but each of these played a very important role in developing of specific and autonomous law and order in the European Union. Say, still discussion goes on about the opinion or conclusion 2/13 about the legitimacy of the EU joining the Convention on Human Rights and Fundamental Freedoms. In this case, the opinion of the court has paused, or I would say they placed a point about discussion, ended the discussion whether the EU should join the convention. Advisory opinion of the European Court of Human Rights is of recommendations. Advisory opinion is possible in 3 options. First, on following the Article 47 of the Convention, when the opinion is requested by the Committee of Ministers, and then very narrow range of issues So only two conclusions, only two opinions were expressed through whole history. Then appointment, election of the judges of the court. Another aspect is less known, but I believe next year it would be launched. It's advisory jurisdiction that is arising out of other treaties and agreements. The response is obtained, but the Committee on Bioethics of the Council of Europe, according to the Article 29 of the Oviedo Convention, this stage envisages an opportunity to approach for the European Court of Human Rights. And third option that a lot is being spoken about, they place a lot of hopes, even though I'm skeptical in this respect, one may argue about it. Its advisory opinions within the framework of Protocol number 16 entered into effect in 2018. This protocol envisages responses to requests of higher courts of members of the Council of Europe, which ratified this protocol. In 2018, the protocol entered into effect. This opportunity has arisen. First opinion was expressed following the request of France. They expect opinion following the request of Armenia. So your country became actual leader in testing this kind of protocol. In this specific case, one of the leaders within the framework of the European Court of Human Rights. The request was obtained in 2020 in April. Very interesting issue, I would say. It's the right of law, so the right of court to refuse the advisory opinion following the request. International Court of the UN refused to respond to the request of the WHO about the legitimate nature of making use of the nuclear weapons. One of the notoriously known case of refusal following the procedural grounds, because WHO was not competent to file this kind of request, this general type of request. However, so International Court of the UN worded its rule to refuse to follow, to offer opinion following this kind of request, but they never realized this right. According to the scope of competence, they are appropriately authorized to consider the case or refuse, turn down the request in order to protect the judicial function, holistic judicial function of the court as the major court of the UN. So in all cases, whether they consider the case or they turn down the case. Last time, the International Court reiterated this attitude in their advisory opinion in 25th. So from separation of the Chagos archipelago out of Maurice. So they never refused advisory opinion based on this ground, particular ground. Even though in a number of cases the court has been considering very important political issues, advisory opinion on the legitimate nature of building the wall in Palestine. More evident, say more practically oriented position is taken by the Inter-American Court on Human Rights. A number of times they were faced with a situation where the countries, the governments approached the Inter-American Court, offering the advisory opinion, thinking they would make use of the opinion in the interstate political situation, interstate conflicts. In 4 cases, this court refused to offer advisory opinion, and they motivated. So the court has to act carefully, so that make sure that their advisory jurisdiction is not used as the tool in political debates. So this was specifically and very clearly stipulated. Advisory opinion in the court of the EAEU. Well, in fact, yesterday I was very pleased to listen to the introductory word of the chairperson. A lot was done. One detail, so one way, it's also part of my presentation, 17 advisory opinions within 6 years of the activity of the court. In this respect, within a specific period of time, the court of the EAEU is absolute world leader among all international courts, which we may simply extend our sincere congratulations. Majority of this advisory opinion were following the requests, were issued following the requests of the European Economic Commission. So the Permanent Chamber of International Justice, or International Court, they are issued or offered following the requests of the institutions and organizations. In this kind of situations, the number of advisory opinions, so the necessity and efficiency and importance, the link between the European Economic Commission, Eurasian Economic Commission, it's not just a defendant, so it should be considered as a partner in building the order in the Eurasian Economic Union. So advisory opinions could prove it that the court is developing its doctrine to establish law and order in the Eurasian Economic Union. Of the direct application, directly applied, they will have to take it to word the doctrine. So they are more so advisory opinion are more comfortable, more clear, but it underlines the necessity so that the court to offer the advisory opinion needs the request of the partner. So it should be appropriately worded and qualified from the partner and the ally, with appropriate wording, with appropriate understanding, so to make sure that the court is able to answer, and in which way the opinion of the court may solve this or that kind of problem that at the level of the Eurasian Economic Union the states are faced with, or the institutions of the EAEU, options of use. So the clarification of the provisions of the treaty necessary to function of the advisory opinion on pensions, very interesting approach, which I believe that would be used actively in the future, unless they would be implementing the forecast that the right of the Commission to approach the court would be reinstated, putting claims against the states that are violating their rights in the US, in the EAEU. So the infringement proceedings, the court jointly with the Eurasian Economic Commission looking for the replacement kind of infringement proceedings. So that's the filing the case against the state in the advisory opinions. And the advisory opinion as the means of solving the problem, saying the disputes that are arising between the countries, the states, and institutions of Eurasian Economic Union. The similar advisory opinion on leasing. It's clear, known to everyone, when the Russian Federation finds itself in an abyss, or kind of abyss, stalemate, following tough position taken by the Eurasian Economic Commission. The Russian Federation believed that that law on leasing should be amended. The situation was successfully resolved to satisfaction of all parties concerned through the request to provide advisory opinion on followed by the Russian Federation request. What one could expect, what one could envisage, which way the advisory opinions of the court of the EAEU. Mr. Baishev, the chairperson of the court, considered the divergence of the positions of the chamber of the court, and an appeal was considered. The second appeal was looking at the other opinion, was grounded on other opinion. In this case, I believe more efficient there will be an option to approach the Eurasian Economic Commission, so that we should follow the development of the situation and should look at the situation that is taking shape with the interpretation of the EAEU court, and that should assist the court in solving this, rather than the current situation when the court finds itself that have to find legal form of resolving the problem. So I apologize, this is actually the last slide of my presentation. Accordingly, they have absolutely legitimate grounds to provide requests provide opinion following the request and offer the advisory opinion. So winding up my presentation, I would say the well-balanced and rational approach to advisory opinion may generate very huge favor of benefit for the court of the EAEU, and the advisory opinion in building and developing and deepening the order is simply ahead of us. Thank you very much indeed, Alexei. As always, very interesting presentation, a lot of practical information, which we needed very much. As the time is pressing, I may be, making you happy. So advisory opinion 17 were already issued. We also have others which are being considered. So you are right. It becomes kind of a major functions. A lot of requests are received, and we are considering them very seriously. Thank you very much indeed.
Now I'd like to invite Dražen Petrović to take the floor, registrar at the Administrative Tribunal at the International Labour Organization. He'll be talking about harassment at the workplace and in international organizations. Good afternoon, or good morning, as the case may be. Welcome. Looking forward to your talk.
Thank you very much, Madam Chair, for giving me the floor. It's good morning for me and good afternoon probably for some of you, which is the beauty of this nice planet and different time zones. It is my honor to participate in this panel with such prestigious co-panelists, and I thank you for the invitation and opportunity to intervene here. Instead of reinforcing multilateralism, the current sanitary crisis has, in my view, only strengthened trends towards reinforcing the role of the state, both internationally and internally. The current trend is rather every state for itself than international cooperation. In that context, a conference organized by an international court of justice is particularly important. The rule of law is essential for a proper functioning of an international organization. However, we should not forget that organizations are not composed only of member states. They also have their own staff, and the court of the Eurasian Economic Union, like the court of the European Union, has also the jurisdiction over disputes between the administration of the Union and its staff. In that aspect of the court's work, I was already in contact with the courts through Judge Seitimova and Deputy Register Entin. Contrary to the European Union and the Eurasian Economic Union, many other international organizations opted for the creation of their own or recognized an existing specialized administrative tribunal dealing with those issues. The Administrative Tribunal of the International Labour Organization, just mentioned by Professor Ispolinov in the context of advisory opinion of the International Court of Justice, is the oldest and the most influential among those tribunals, with more than 4,300 judgments adopted until today and with more than 60 international organizations that recognize its jurisdiction, among which are the majority of United Nations specialized agencies, International Organization for Migration, World Trade Organization, the Organization for Prohibition of Chemical Weapons, CERN, or the International Criminal Court, just to name a few of them. The type of issues that the tribunal is facing corresponds to the trends in society. Some officials challenge the way their employment was terminated, others claim social benefits. And one of the issues that has triggered particular attention lately is the issue of harassment, which has become increasingly important in the world, especially in the Western Hemisphere, and its significance for the world of work is growing. The ILO itself, International Labour Organization itself, has recently adopted in 2019, during the conference celebrating 100 years of its existence, the Violence and Harassment Convention 2019, which is number 190 in the row of conventions, and related recommendation number 206. This means that the fight against harassment becomes a global concern. Consequently, the number of cases before the ILO Administrative Tribunal arguing that the complainant has been a victim of harassment has increased in recent years. This situation permitted the Tribunal to clarify several aspects of its case law and through this case law to influence internal legal systems of all 60 organizations under its jurisdiction. One of the main difficulties that the Tribunal is facing is the lack of uniform definition of harassment. The Tribunal cannot give its own definition of it, but has to rely on the way the organizations defined in their staff regulations and rules. Although those definitions are often similar, they can differ in many elements, and the Tribunal has to respect that since those definitions belong to the applicable law for each organization. This practically means that the Tribunal has to face 60 applicable laws and has to adjust itself to it. In substance, we are talking about unwelcome, aggressive, and offensive behavior. In Judgment 4253, the Tribunal explained that harassment may involve a series of acts over time and can be the result of the cumulative effect of several manifestations of conduct, which taken in isolation may not be viewed as harassment even if they were not challenged at the time when they occurred. However, despite these difficulties with definition, the Tribunal insisted on one essential element, and with the time it has been generally accepted. It is that there is no need to prove intent on the part of the alleged perpetrator in order to establish harassment. A key element of harassment is the perception the person who is the object of the contact may reasonably and objectively have of acts and remarks liable to demean or humiliate her or him. The case law tribunal recognizes three types of harassment. First is the moral harassment or simply harassment, the well-known. The second is sexual harassment, and finally institutional harassment. The third type, the institutional harassment, is less known, and it occurs when it is difficult to identify one single person or one single incident that caused prejudice to an official. The tribunal stated that, and I quote, "The decisions which appear to be managerially justified when taken individually can amount to institutional harassment when the accumulation of repeated events of mismanagement or omissions for which there is no reasonable explanation deeply and adversely affect the staff member's dignity and career objectives. The decisive element of that there is no reasonable explanation for such decisions or acts." The first two types of harassment, namely moral and sexual harassment, are well known and widely recognized. They involve the relationship between two or more persons. However, many organizations are making a serious mistake by considering the harassment exclusively as a problem between persons. It is wrong to argue that the alleged victim has to prove harassment to a certain standard of proof necessary to prove the guilt of the alleged harasser, which according to the case law of this tribunal is the standard of beyond reasonable doubt. In fact, in the heart of the reaction to any harassment is the administration of an organization. Since an international organization has a duty to provide a safe and adequate working environment for its staff members. This includes an obligation to ensure a harassment-free environment by ensuring that no staff member is harassed in the workplace. The administration has therefore double responsibility. On one hand, to protect the victim of harassment, and on the other hand, to punish the perpetrator who committed misconduct. Those are two different legal relationships. The tribunal has recently, in its full composition of all 7 judges, adopted Judgment 4207, which in consideration 14 states the following, and I quote, "A claim of harassment and the report of misconduct based on an allegation of harassment are distinct and separate matters. A claim of harassment is a claim addressed to the organization, the resolution of which only involves 2 parties, the organization and the reporter of the harassment. In contrast, a report of alleged misconduct based on an allegation of harassment triggers a process that is directed at the culpability of the staff member in question and potentially the imposition of a disciplinary measure. In this process, the 2 parties are the organization and the staff member in question. In this process, the two parties are the organization and the staff member in question. In this process, the reporter of the misconduct, a potential victim of the harassment, is a witness and not a party in the proceedings. In other words, the perspective is different for the administration in two situations. It faces different persons, has different obligations, and has to meet a different standard of proof when dealing with an allegation of harassment made by a victim or when it supposes to punish an alleged harasser. The overall rule is that harassment cases should be treated as quickly as efficiently as possible in order to protect staff members from unnecessary suffering. However, for an organization to be able to do so, someone has to report harassment. Normally, it is presumed victim. In many organizations, the harassment can be reported by a person other than the alleged victim. This could be a whistleblower, the manager, or any other official who, according to some internal rules, are under obligation to report harassment. The tribunal has also stated that given the serious nature of a claim of harassment, an international organization has an obligation to initiate the investigation itself. Secondly, the reporting of harassment has to occur quickly to enable the organization to act accordingly. This is necessary to gather reliable testimony from witnesses as to whether those incidents occurred and how third parties may have perceived them. Thirdly, the allegation of harassment has to be borne out by specific facts, and the person alleging harassment bears the burden of proving the allegations. Sometimes this may be difficult, and it is understood that an accumulation of events over time may be cited in support of such an allegation. An unlawful decision or inappropriate behavior is not enough to prove that harassment has occurred. In other words, it is not enough simply to mention the word harassment in a grievance addressed to the administration. Very often, organizations have a special procedure to deal with harassment complaints. If the person concerned has failed to address its harassment claim to an appropriate body, the administration has a duty of care to direct the person towards the correct procedure. Having received a claim of harassment, the investigation must be initiated promptly, conducted thoroughly, and the facts must be determined objectively in their overall context. The way the investigation should be conducted is a question that merits much more time, and I will try to elaborate more in a written contribution to the acts of this conference. Upon the conclusion of the investigation, the alleged victim is entitled to a response from the administration regarding the claim of harassment. As the tribunal established that the standard of proof for misconduct is beyond reasonable doubt, which is a relatively high standard to be met, there was considerable misunderstanding of the case law that the same standard applied when the determination is to be made whether harassment occurred for the victim. The tribunal determined that a lower standard has to be met here. Once the finding has been made by the administration, administration has to put an end to it as quickly as possible, and it has to take effective and immediate steps to prevent any further harassment. Those steps may include counseling the perpetrator of harassment or relocating the staff member, the subject of the harassment, to another workplace or even another position. The organization has to restore the victim to a normal work situation and, if necessary, redress the injuries caused. Ordinarily, this redress takes the form of monetary compensation for the injury suffered. Even if the organization determines that another person harassed one who alleged the harassment, it is liable for injuries. This situation differs from national legal systems. According to the tribunal's case law, by virtue of the principle that an international organization must provide its staff members with a safe and healthy working environment, it is also liable for all injuries caused to a staff member by a supervisor when the victim is subjected to treatment that is an affront to her or his dignity. Those are obligations towards a victim. As for the alleged perpetrator, the organization may, within its discretionary power, decide to start disciplinary proceedings that may lead to dismissal. It is for the organization to do that, and the victim has no right to claim punishment of another person. Many organizations have announced zero tolerance towards the harassment, and there is an increased number of cases before the tribunal involving punishment of harassers. The disciplinary procedure must provide all guarantees of due process, although in the case of sexual harassment, some assumptions arising from pattern and behavior may be drawn and the protection of the victim or witnesses may be reinforced. This was a concise guide into the relevant REACH case law and remain available to assist the Court of the Eurasian Economic Union with more detailed references should it be in position to deal with harassment cases. Harassment is a practice that should not have place in international organizations, and all international courts and tribunals should help organizations to deal with it in an appropriate manner. Thank you very much for your attention.
Very interesting. And we listened to you with great enthusiasm. We will be glad to meet you again. Переходим к следующему нашему спикеру.
We are going to give the floor to our next speaker. Yes, it's Christopher Campbell Holt. He is the chief of the Secretariat in the International Center for Arbitration of the Astana International Financial Center. The topic of his presentation is International Court and Arbitration Center as a platform for resolving commercial disputes in the EAEU.
So the floor is yours. Благодарю вас. Хотел бы прежде всего поблагодарить вас и поздравить именно организаторам нынешнего мероприятия. Благодарю представителей организаторов, должностных лиц суда ЕС. Важность этой темы, несомненно, я присоединяюсь к Казахстану с точки зрения ЕС также. Прежде всего, в те усилия, которые предпринимаются Казахстаном, в внедрении Казахстаном при решении и начали работу финансового центра в Казахстане. В Астане финансовый центр.
We created, excuse me, a world-class commercial dispute resolution facility consisting of an independent court and also an independent international arbitration center. These centers were created to provide the similar type of dispute resolution that one might be familiar with from other financial centers from other parts of the world, in particular from London with their common law commercial court based at the Rolls Building in central London, and also with New York, with Singapore, Hong Kong, Dubai, Qatar, Abu Dhabi, and some other countries. Kazakhstan did this very importantly to provide the strictest possible international standards of the rule of law to protect the rights of investors who are now coming, increasingly so, to the AIFC, to Kazakhstan, and indeed for the whole of the Central Asia region. One of the points of this court is that it is completely separate and independent from the legal and judicial system of Kazakhstan, the Republic of Kazakhstan. Again, this is very similar to other types of courts in the Middle East, in particular in Qatar, where I worked previously to set up a similar financial center international court, and also in Dubai and Abu Dhabi. This is important because it provides investors with, for the first time in this region, a credible international alternative to resolving their disputes compared to the local legal or judicial systems in place. When we set up this court, we set it up in towards the end of 2017. We became operational with effect from the 1st of January 2018. We have since that time considered and decided 8 cases. We have a number of other cases currently ongoing. The judges of the court are very important towards the independence and the international perception of independence of this court at the AIFC in Kazakhstan. The Chief Justice, the first Chief Justice of the AIFC Court was Lord Wolfe, the former Lord Chief Justice of England and Wales. He has recently retired and has been replaced by Lord Mance, the former Deputy President of the United Kingdom Supreme Court. He is supported by 9 world-class judges, all from a common law and also other international dispute resolution background. The pedigree of the judges is unprecedented for this type of court anywhere in the world. And it has comprised a bench of judges with the highest international standards of commercial dispute resolution. Our court does not handle criminal disputes, criminal law disputes, or so-called administrative law disputes. What it does do is, and is already doing successfully in practice, is to administer typical contractual disputes, non-payments under contracts, investor contracts. Our court has jurisdiction to consider not only disputes that are of a commercial nature involving individuals and or companies, legal entities, it also has jurisdiction to consider disputes of states. And indeed, this is something we do expect the court at the AFC to be considering from an investment perspective in the near future. I've said that this court at the AFC is completely independent. The independence of our court is guaranteed in law in Kazakhstan. Regulation 11 of the AFC Court Regulations 2018, which provides for the constitution of the AFC Court, among other important matters relating to the governance and operation of the AFC Court, provides that the Chief Justice of the Court and the judges shall have complete independence and shall act independently and impartially. Regulation 11 subsection 2 provides that neither the government of Kazakhstan, anyone else at the AFC, or any other person or entity shall interfere with the judicial duties or decisions of the Chief Justice of the Court or judges. Now that provides a cast iron support for the total independence of our judges. That is backed up in practice on a day-to-day basis by the reputations of our judges who have developed their judge careers in London and elsewhere around the world to the highest international standards, based specifically on their independence and impartiality when giving judgments, to treat all parties fairly, to treat all parties with the greatest respect and equality, and to provide maximum access to justice to the court so that the court is available for all. In that regard, we have provided our services completely free of charge at the AFC Court to all parties, no matter what their background is. The court provides judicial mediation, where a judge will consider on a mediation basis, if the parties so request and consent together on a particular dispute, the chances of a dispute going to court and also to further litigation, but also to try to resolve that dispute in an amicable way. That judge on a judicial mediation would not then participate as a judge in the actual litigation proceedings if that process does not work and the parties feel that they need to progress to litigation in the court. The decisions of our court are completely final. They cannot be supervised or reviewed or appealed by any other body or court, including our dear friends at the Supreme Court of Kazakhstan. I should say that while the AFC Court is completely independent of the other courts of Kazakhstan, it is in a close friendship or cooperation of understanding with the Supreme Court of Kazakhstan and the other local courts, not for any interference or working together on cases, but specifically for an understanding, so that the local courts fully support and understand the independence and are able to support us with what that actually means in practice when we are administering serious commercial disputes. All of the cases at the court have been enforced within the territory of the Republic of Kazakhstan, not just within this new financial centre, but throughout the whole of Kazakhstan territory. And this has been done with remarkable expedition, remarkable speed, and free of charge to the parties. We have developed a special step-by-step procedure for enforcement. I happen to be the enforcement judge at the AFC Court. I have a very hands-on role in ensuring, with the support of my excellent internationally trained case management team, to ensure that all of the correct enforcement agents are in place, sometimes ahead of time, but always very quickly. And that within a matter of hours or days, the judgment is always, without fail, so far at least, enforced to 100% satisfaction. This has proven to be very successful so far for the AFC Court. We have done all of this, not just because of COVID-19, but we have done all of this online. We do have the good fortune of world-class physical premises in the Sultan, Kazakhstan. We're utilising the Expo 2017 site, which I'm sure you're all familiar with, as being a truly world-class physical premises. However, it has not been necessary during COVID-19 because we have developed world-class digital technology. We operate from our e-justice system. This is an electronic platform, which is again provided free of charge to all parties on cases. And what it does is allow parties, whatever time of the day or night, 24 hours, 7 days a week, to access free of charge their strictly confidential papers with a special secure login account. The judges also use this account and can work on papers remotely and save them, so there is no need for parties to travel. This, of course, saves enormous expenses, both with hotels, business travel. And of course, for some people, it's not even possible to travel. So this has proven to be an invaluable asset to help resolve commercial disputes in Kazakhstan. Why is this court of particular interest, in our view, to the Eurasian Economic Union? While our court was created primarily to support the needs of commercial enterprises, individuals and states on commercial dispute matters for Kazakhstan and for the AFC, it does have very wide jurisdiction. And that jurisdiction allows, in practice, anyone, provided they agree in writing, again in any language, applying any rules or any laws, to use our court. Why would they do so? Well, perhaps the dispute or the contract at the heart of the dispute provides for the application of English law or New York law or some other form of common law. Or perhaps it applies for civil law, Kazakhstani law or other types of law from this region of the Eurasian Economic Union. But perhaps the parties would otherwise be in London or in some other international financial centre dispute resolution forum for their disputes. Well, now that's not necessary for parties because you can come free of charge and very quickly to our world-class dispute resolution facility at the AIFC in Kazakhstan. We are already receiving queries and requests for potential dispute resolution from parties throughout the Eurasian Economic Union. And again, all the parties have to do is agree in writing to have jurisdiction at our AIFC court. We fully support and endorse this approach of parties throughout the Eurasian Economic Union, and we encourage more parties to cooperate with us and to work with us to see how we might be able to assist with their dispute resolution to the highest international standards. We are, as an AFC court party, a party to various international enforcement arrangements. So we are a member of SIFOC, the Standing International Forum of Commercial Courts, based from the Commercial Court in London, at the High Court in London. And we have members of, I think, more than 35 jurisdictions around the world, all with in mind the closer support and supervision of international enforcement of our, on a mutual recognition basis, of our judgments and orders. So, in addition, I want to very quickly highlight that we also have a separate independent entity at the AFC as a part of our overall dispute resolution platform called the International Arbitration Centre. This is chaired by Barbara Doman QC, a very distinguished international arbitrator, mediator and litigator. We have access to world-class arbitrators. We are already attracting we have attracted more than 274 cases, specifically focused on arbitration and mediation. And this really has enabled us to provide a world-class one-stop package of dispute resolution facilities for international standard commercial dispute resolution. And as I said before, this is not just for individuals or commercial enterprises. This is for states as well. So we welcome everyone to consider us as a serious place to resolve disputes quickly and cost effectively, and utilising our latest digital technology to assist in the greatest possible way with the dispute resolution process. And I want to say one more time that our court and our arbitration centre are completely independent, applying the highest standards of independence and impartiality with the strictest adherence and application of international standards of the rule of law. Thank you very much.
Thank you. Уважаемые участники конференции.
Respected participants of the conference, as we are slightly behind the schedule, and since we have received the question, I would be brave enough to reduce the time for break and switch to discussion. We received a question from Sambatyan. Question to Mr. Dedov. Are you with us, Dmitry?
Дмитрий Иванович нас...
Mr. Dedov, are you with us?
Да. Слышно меня?
Well, again, just thank you for being with us. Well, if something happens, Mr. Kovalev would be able to help you, or I would be able to join. The question is as follows. We wonder whether the court, so it's Anaid is asking you, whether the court in administration of justice has to take into account values, specifically in cases when the parties adhere to different values. I wonder whether this kind of situation, the case would go down and fall into abyss of ethics. Very good question. Thank you very much indeed for the question. Well, the issue is we cannot go away from the values in case they are the ground, the foundation of the interest of the parties, but as well their rights and freedoms. So these rights and freedoms are based on certain values, and we will have to take them into account. Roughly speaking, values are parts of the interest, parts of the ground for the rights and freedoms, and then as an element of impartial and unbiased analysis. It does not mean that these values as political phenomena will have to dominate over taking decisions or decision-taking process. Well, they are the grounds, so they are taken into account. Where these values are in conflict with one another, it results in conflict of the interest of the parties, their freedoms. For example, conflict which is evident, the conflict of freedom of expression of opinion and conflict of the reputation, protection of reputation of an individual. Well, his good name or her good name, and so they evaluate from the point of view to what extent the expression of the opinion was justified, was at least grounded on, according to the standards, some specific circumstances that have allowed arriving at conclusions. In each specific case, these values, they are in conflict, they are balanced, they are weighted, the interests are considered, evaluated from the point of view of the legitimate objectives. And generally speaking, from the point of view of methodology, it's not a very difficult or complex issue. Another thing is one has to take into account all circumstances. For example, recently, in the court, the more and more frequent difficulty arises of weighting the freedom of expression of one's opinion and the form of expressing the freedom that is often expressed like via things like known as hate speech. So that's expression of hatred to an opponent in a case when rational debates, rational discussion of certain specific important issues for the society goes into or crosses the border or goes outside the borders. And becomes the intention to insult another person. So, from the other hand, the individuals that are officials in the government, they cannot be relieved from any criticism. However, this criticism should be unbiased, well-grounded, arguments should be provided, the criticism should be of neutral nature. Standards allow for a certain element of shock. Certain element of artistic improvement of the evaluation of the actions of the relations, but they should be proven by the facts. So each time, behind certain emotional, moral conflicts, there are always a rational evaluation behind. And this is the essence of the art, that one uses the means of exaggeration, but however staying within the framework Well, finally, in the long run, there must be prevailing such values like mutual respect, respect to dignity of an individual. And then I presume that one may find solution to conflicts, transferring them from emotional sphere into rational one, calming down. So then if an effect arises when both parties are happy with the result, even then the party that have lost in the court, in case they understand and they see that the circumstances are against this party, so this party then understands that the decision should be accepted, should be recognized. So this would be my answer. Thank you for your understanding. Anaid, are you happy with the answer? Well, if not, then we'll have the second part of the section. She will take the floor and she might express her opinion. So there is a question of Ms. Sitimova. Seems to be she's going to voice it herself, and she would specify the addressee, the recipient of the question. So please make sure that she is with us. Welcome. Who is the person that is supposed to answer this question? We cannot hear the sound. Please put your mic on. Your mic doesn't seem to be on.
Сейчас попытаюсь. Хорошо.
Well, the question asked by Kirill Entin to Mr. Dedov and to Mr. Kovler, the one who is ready. In the Russian Federation, they completed the preliminary selection. Then the president would submit the candidates of the Court of the Human Rights representing the Russian Federation. In this respect, I would like to ask Dmitry Dedov and Anatoly Kovler, what are the major qualities and competences that the judge of the European Court of Human Rights should possess? Who is going to answer? Well, I would give the floor to Anatoly, if he's with us. Okay, Dmitry, welcome. Welcome you guys both. As the member of the Commission, I will have to comment this, whether I like it or not. Well, certainly this year was really a very open procedure of selection of candidates. There were 34 candidates. So 7 nominees did not know the second language, they were discarded. So there was a test of 2 languages that are used as working languages. In 18 nominees were successfully passing. There's a very strong, competent candidates were considered. So the short list of 6 candidates was set up, and this was openly placed on the website of the Ministry of Justice. So these names are known. The question was as follows. Kirill's, what are the qualities that the judge should possess? Well, you know, as of the first day in the European Court, I have been remembering the words of Dante. When Dante was filling Virgili to the hell, so it was purgatory, yeah, well, just losing consciousness. Virgili was saying that you need to have the soul very, and then so that no one should give advice in this kind of circumstances. So this is the most important, the highest value. Don't be afraid to go against your own state. In this case, in this respect, even though Erna, you might disagree with me, in this kind of situation, this the ground, the reason, because the judge has to accept a difficult decision. Situation may differ considerably. Well, here, if Ms. Sabatyan was arguing the values considered in the international justice, so I'm very happy that we are of the same opinion with Dmitry. I believe that the ground, the essence of the after-war justice is value, or values. So it seems to me that the judge of any court, not only European Court of Human Rights, or other courts, should show balanced approach to these values, proceed from the proportional approach. So if we take the problem of the rights of property, so we know that European Court constantly pays attention to weigh the balance between the public and individual interest. In his or her decisions, the judge has to proceed from. This is in brief. But take into account that the short period of time we have. Well, I'm taking part in the discussion. Where from do you get these doubts? Because you thought that I might be of a different opinion, so don't be afraid to go against your own state. So I'm not the right person to be suspected, because in my labor activity as a judge, I always have been adhering to the point that the framework of the law should be respected, and then goes the rest. Erna, I'm a patriot, but this was kind of teasing. Just to make a discussion more vivid. Well, at present, I'm representative of the state that doesn't live through its best time. But at the same time, it doesn't make me weak. And then please remember the country I'm originating from. Erna, if you don't mind, I would elaborate. I would add to what Anatoly mentioned another aspect of this, of what competences and requirements to the judge they are envisaged by the convention. So they envisage some place or element in the national system, that there's some contribution that the individual made, his or her moral qualities. So we consider this kind of requirement, but they determine the nature of the justice. If we speak about judicial power, if we speak about the activities in taking decisions of the court, well, the power itself is taking qualitative decisions, high-quality decisions. Special attention is paid to in the European Court of Human Rights, so that carefully, very carefully consider the cases without any prejudice to any parties, to any states, to any applicant, and taking into account all circumstances, evaluating them multifacetedly, taking into account the values that this approach are grounded on. The comprehensive process in decision-taking, any decision, It's not only approach of international bodies, it's always not simple, not that simple, but this is the essence of the compliance, or whether this person can be entrusting with this judicial power, whether he or she is capable of taking decisions in an unbiased manner. So that it's not only the loyalty, but not only in relation to the state, because he or she has to be deliberate in evaluating the interests of the claimant. This is the role, definition of the competence. They don't have the mechanisms rather than resolving the dispute in a way so that they are acceptable to both parties. So it's quite easy to achieve, but at the same time quite difficult. Well, thank you very much indeed. Well, again, coming back to Anatoly, for the judge to be able to act as independent from the point of view of any pressure of any state, it's the state that should be should not adhere to pressure exerted on the judge. So I'm very pleased to note that my state, for all these 6 years, there hasn't been any attempt to exert any pressure on me. That I'm very proud of, and I'm openly saying about it. What concerns all other issues, would you able to elaborate what Kirill Entin has asked about? Erna, I entirely agree with you. During 13 years working in the European Court, I never received any instructions on the government, on the part of the government or the state. So there's some rumors saying that some was unhappy with our decisions. But the major factor of pressure were the lawyers, arrogant lawyers, that were evidently saying that possible decision might be this and this and this. And claimants, of course, and certainly the press. They are real friends, in inverted commas, of any justice. So this was external pressure. Sometimes that was, putting me on the edge of nerves. So the authorities should understand that they are discrediting the judge that is elected from this or that country in case they're under pressure. In this respect, we are happy people. Probably, yes, I agree with you. Thank you. Then we have another question to consider, as we were unable to get in touch with the person. I would voice a question. So the question is to Dražan. Dražan, are you with us? Well, she wanted to send best regards, first of all, and ask the following question. How to make sure, if I'm not mistaken, I have been carefully listening to, so he mentioned in there, how to ensure the protection of rights of persons who failed to go through the competition process in the international organization. Very serious question.
Every person has right to, every person participating in selection process has right to question aspects of that process. But there are some limits in the case law. The first is that if you were not shortlisted, you cannot question final result, because you don't have cause of action, because you didn't make it to the next stage. So you can question the selection process from procedural point of view or from substantive point of view, saying that your qualifications or that your application was not fully taken into account. But success in challenging selection process is not that high, because it is discretionary power of administration to assess capabilities of candidates. So it is most of people who won before the tribunal were those who succeeded in pointing out procedural flaws.
Есть еще какие-нибудь вопросы? Вас благодарю.
Other questions to follow? Thank you. Dražen?
Так, пожалуйста.
Go ahead.
Слушаем.
Go ahead.
Да, кто? Вы могли бы знать?
Who is asking?
Крис Холт.
The question to Chris Holt.
Ставил в известность, что хочет
Thank you, Chairperson.
Who would like to
So,
comment?
вопрос и ответ.
I'd like to make a very quick comment, if I may, on a previous question, which was
Okay.
answered by one of the panelists. It
Хорошо.
relates to interference by, or perceptions of interference by states on court decisions. I wanted to reiterate that our court at the AFC in Kazakhstan, the International Commercial Court, has been, as I said before, my short presentation, operational for 3 years. We've considered a number of cases so far, and we have more ongoing. At no time at all has there been any suggestion or breach or interference with our decisions by anyone. One of the practices which we have noticed in our 3 years experience of running cases at this court has been that some parties like to turn to social media to make all sorts of allegations, completely inappropriately in our view. We do not get involved in that, and we are aware that some people like to make allegations that perhaps their friends can interfere in a decision of a court or of a judge, and I'm happy to say that that's been absolutely most robustly ignored and at our court, and has not been relevant at all to proceedings. So our court is completely independent and has respected and will always respect the highest standards of independence and the rule of law.
Спасибо. Thank you.
Thank you, sir.
Уважаемые коллеги,
Dear colleagues,
что мы нарушили регламент,
given that we are
я
beyond
предлагаю
or behind schedule,
объявить перерыв.
I suggest we do announce a break at this point
Следующее наше заседание
and
начнется
announce a lunch break, if I'm not mistaken.
через 5 минут.
No lunch break for now. 5 minutes. We start in 5. Thank you for your attention.
Спасибо.
Продолжаем работать. Значит, приглашается к выступлению Капустин Анатолий Яковлевич.
We are resuming our session. The next speaker is announced, Mr. Kapustin. So he'll be talking about, or he's the scientific advisor, Institute of Legislation and Comparative Law under the government of Russia. The problem of standards in international justice. Good afternoon. Do you hear us? The mic seems to be on mute. Welcome. Pleasure to meet you. Pleasure to see you again. Thank you, likewise. Dear colleagues, first and foremost, I'd like to express gratitude for the invitation to take part in this event, because the Integrational Court and Eurasian integration is our integration. The Russian Federation actively participates therein, actively contributes to the development of the integration process. We're interested in its success and further development. So, undoubtedly, this is a huge honor and privilege to have been invited to this conference. It's just, this is my second presentation, the third one coming up today, so I apologize if I haste through my speech. So, dear colleagues, what I would like to say first and foremost. Beg your pardon? So when we start discussing this matter, where do we begin? The issue of standards in international justice is the one quite debatable. Well, I'm getting echo. Am I supposed to be hearing myself? Right, it's just speakers are echoing back. Right, so the problem of standards in international justice is an interesting one per se. And it is determined by a number of factors. The first factor I would like to identify is the fact that the development of international relations, international law, over the past 2 decades or more, probably 3 decades, demonstrates incomplete development of bodies of international justice. If prior to the World War I, the First World War, these were isolated cases, after the First World War was over, there was a standing chamber of international justice as a League of Nations judicial body. Well, I won't go too much into that history. The different point, the League of Nations encouraged the use of courts of arbitration to settle the disputes between the countries. Then we know that after the Second World War, the International Court of the UN emerged as the judicial body of the United Nations organization. The processes themselves are not simple. So again, where do we begin the conversation about standards in international justice? I would like to showcase the UN's International Court as one of the first bodies of the kind represented international justice. But it's not as simple as that. I will not engage into criticism or sing praises to the International Court of the UN. It does have pros and cons, it's coping, and we see that the international justice as a system, largely, it is developing through the enforcement of judgments. The speakers after me will be talking about interpretive limits of international courts. So, whether we agree with the case, with the precedent or not, well, it goes on. The implementation of the norms of international law is not just visible, it's an inalienable inalienable fact of international reality, and it becomes a well-developed and much visible component. Over the past decades, we've been seeing the adoption of various versatile conventions for various particular matters. In this case, yes, the development is going on. But as for universal, common international law is concerned, that's where the issues begin. The International Court of the UN is in the lead there, but other than that, Mr. Ispolinov did give some examples, but the European Court of Human Rights, other courts or quasi-judicial bodies, they have not been too visible. The development of international law now depends on international justice. So development of standards thereof, understanding and development of these standards, of the elements which have not been properly studied by science, I believe these matters to be highly important. So thank you for creating this section on international justice. The court of the EAEU, given what your statute says, you can also use the commonly adopted principles of international law. In this case, the international justice will be developing with your contribution. Thank you. It will always be going on. The court represents judges which belong to the closest judicial systems. The question is, how close are we in the judicial point, from the judicial viewpoint? We are trying to generalize when there is a serious dispute arising. We are trying to appeal to there is a higher level of harmonization.
Обращать внимание, влиять каким-то образом через свою применительную практику. Это, безусловно, говорит о том, что...
So basically this goes to say that we've been coping with our function and we wish this matter to be conducted the same way. Now as far as standards are concerned, why am I concerned about this system? Well, first and foremost, publications are being prepared for international justice. This year there will be more coming. We've touched upon several matters that pertain the procedures of the court's activities, of various courts, national courts and international ones alike. So I've been paying attention to the fact that various judicial systems, judicial bodies use various approaches to interpretation. Well, not even interpretation, but to enforcing the norms and provisions that the courts have developed for their own operation. Why am I referring to this? We have literature references and well-known scientists. When they refer to standards of international justice, sometimes they refer to international standards, and that's a different thing. So we do understand that some standards are overarching and they are shared by national and international courts alike. However, impartiality of judges, lack of bias when considering the case, independence of judges, this is equally welcome at the national level and internationally. Definitely this is the case. Regardless of the level. So no questions there. However, if we were to consider the system more carefully, or this system as it emerges. I don't think that it has taken shape completely at this point. So if we look at the multitude of at the array of international justice bodies right now, the situation may look different. International Criminal Court and other hybrids that emerged for specific questions, to address specific matters. International criminal liability of individuals begs for higher standards. The Rome Statute of the ICC does contain certain special provisions that basic principles of legal systems will be used. So the formation and the emergence of standards is welcome by the ICC in particular. However, there are courts on human rights. From the previous session, the way I gathered, there was an active discussion about courts that don't just enable individuals to act as claimants, but they are specifically geared towards protection and upholding the human rights and freedoms. The competencies of these courts is limited with these matters. So the approach there might be different. However, if we take the European Court on Human Rights and other courts, say in Africa, there is a Court on Human Rights, Latin America, even this close approximation, or when we use this close approximation, we see that the standards are not exactly the same. So these courts are different in the way they administer justice. So it would seem that the courts on human rights is a homogeneous kind of category, but it's not the case. Maybe some norms and principles are the same. And we do know Ms. Smbatyan maintains the concept, and it's quite well known in our literature, that courts can interact informally, using their own cases, precedents, legal standpoints, no matter how you spin it. So this is one of the ways courts integrate, courts integration. Can we refer to it as the standard of international justice? Well, I'd be cautious to make a statement that rash. So a lot more contemplation, consideration is required. Or the example that you serve as, the court of the Eurasian Economic Union, the Union Court. Somebody will say that yes, this is integrational justice, or somebody is more cautious, courts of integration associations or integration blocks. Where there is access by states, by legal entities, and by individuals to a court, well, in most cases, it is the state that is one of the sides to the process, one of the sides to the dispute. Sometimes it's a state against the other state. These observations have been published by our Deputy Minister, by the Ombudsman on Human Rights, Mikhail Galperin, Deputy Minister of Justice. He directly said that the ECHR does not trust anyone. It considers various disputes. However, the standards for consideration are different. Say, the burden of proof, or the standards for proof for individuals and for legal entities are different. So, is this situation admissible in your courts, or you treat your potential clients, your people that come to you equally? So the principle of equality between the parties, is it maintained, or other preferences? Individuals are weaker, less protected, so they should enjoy higher protection standards. The way I figure, there is indeed a multitude of problems here. One that I've been saying talking about for a long time, and I would like to say it out loud, given the composition of our audience, these respected judges that are listening to us. You remember when I talked about the standards of proof, or other standards? Well, standards are as they're understood. They're established somewhere in covenants, in statutes, in international treaties, and so on and so forth, where the countries actually sat together and determined various norms and principles. Say the norms that used to defend, the principle of how the courts are formed, the principle procedures for court proceedings. You know that courts decide on their procedures themselves. This sin is stemming from the Russian history. When one of the international courts of arbitration was put together, when the first Hague conference was in full gear, there was a session where our representative was an arbiter in the dispute between the UK and Guyana. So why is this tribunal known? The rules of procedure were drafted back then, because previously the judges were not guided by anything other than their personal experience. They had experience of working in national courts, so they agreed on procedures already during the proceedings. Martins said that we are judges, we are supposed to install the procedures before we proceed, before we go ahead with the case. So they have done it back in the day. Now we are posing the question differently. Whether these norms, particularly the ones that are handling sensitive issues, interests of state and so on, should they be not elevated, or should they be elevated to the international level? So it shouldn't be a secondary act. You know this term, judgment rules. This term is circulated in the literature. The norms established by judges. Nobody doubts the impartiality of judges when they pass this and when they put these norms forward. But the aspect of equality still exists, and it may be contended. I'd like to wrap up my presentation because I know that there are many people to take the floor further. Well, having raised this question, I would like to thank you for the attention. Thank you once again for the invitation to take part. I believe that we will continue our mutual cooperation to the benefit of our integration. Integration is a serious matter. The scientists are serious as well about it. So we intend to do our best to develop this. Thank you very much indeed. It is indeed a privilege to us, and the manifestation of respect, the way how you participated in our conference. We get to see each other a lot these days. It's very interesting and very productive in every instance. Let us continue our session. I would like to give the floor to Ekaterina Dichenko. She is the counsel to the judge of the Court of the EAEU. Interpretive methods in the practice of course of integration blocks. I would like to thank you for the opportunity to speak. I'd like to focus on this point. The interpretation is the main function of the judicial body, and the microphone is dead. The microphone is dead. It's barely working. Beg your pardon. Some small issues with the microphone. I'll give you my mic. The interpretation of law is the main function of a judicial body, on the implementation of which ultimately depends the effectiveness of justice as a whole. The interpretation is of particular importance for the courts of international blocks, integration associations, since the norms of the law are applied not only by supranational institutions, but also by the bodies of the member states. Accordingly, the interpretation that the integration court will carry out will also enter into the national enforcement practice. Equally important is the fact that the methods of interpretation often used by international courts predetermine legal approaches that have developed in the relevant domains of international relations. Interpretation methods are inextricably linked with the choice of an activist orientation by the court, or conversely, adherence to the principle of self-restraint. The doctrine has long equated the activist trend in the practice of the court and its application of the teleological method. Teleological method being the interpretation on the basis of the goal of the relevant international legal act. Such allegations are based on the example of the Court of Justice of the European Union. It was specifically the teleological method that served as the basis for developing decisions on the landmark cases of Van Gent and Loos, Costa versus NL, Internationale Handelsgesellschaft, which formed the autonomous legal system of the EU and established the properties of its law. The review of the legal positions of the Eurasian Economic Union Court, which by now not only substantiated the properties of the characteristics of the law on supranational education, but also made significant important steps towards the establishment of general principles of union law, demonstrate that it managed to achieve such significant results, applying despite the use of predominantly traditional methods of interpretation. The basis of the tools it uses are the classical methods of interpretation provided for by the Vienna Convention on the Law of Treaties, grammatical, systematic, teleological, and also a method based on the use of pre-prepared materials. At the same time, the very nature of the integration association, which includes countries with different legal systems and traditions, as well as the penetration of supranational law into domestic law and the related need to ensure human rights and freedoms are protected, means the need for the Court of Integration blocks to expand the toolkit of interpretation methods. Well, it's using only the methods developed by it. We're talking about comparative method as well as interpretation in the light of the constitutional principles of the member states. An analysis of the practice of the Union Court shows that the grammatical method of interpretation is used by it most often, found in each act passed by the court. The grammatical interpretation, as mentioned earlier, helps formulate a precedent position. When considering the case on the Kaliningrad transit, the decision of the customs body allowed the court to formulate the position on mutual application, and it ultimately found its way to the customs code of the Eurasian Economic Union. When considering the case on the free movement of goods, assessing the admissibility of the introduction by the member states of unilateral restrictions in mutual trade by one participant, but with strict adherence to the agreement, is also based on grammatical interpretation. One of the most significant manifestations of the systematic method in the practice of the Union Court is the decision of the appeals chamber on the application of general rates, in which, on the basis of a joint understanding of the treaty and the harmonized system convention, the court formulated a universal rule on the application in the Union of an international treaty not signed by the Union. Thus, systematic interpretation fully achieves its goals. It allowed to regulate social relations through the establishment of relationships among international legal norms at various tiers, because the court basically related the Treaty on the Union and the International Harmonized Systems Convention. Characteristics of direct action, direct application, and rule of law in the Union in the decision on the Kaliningrad case, as well as advisory opinions on vertical agreements, on professional athletes, and on attestation, the EAEU court developed using methods of grammatic and contextual interpretation. A comparison is interesting in this case. Formulating similar characteristics of the European Union law, EU, European Union law. It is based not even on teleological method, but meta-teleological method, so-called meta-teleological method. It basically shows that the entire body of activity of this body is aimed at integration, which is the constitutional elements. I've mentioned the Costa Van Gent versus Internationale Gesellschaft. The court formed positions without any particular matter. The thing is, the Articles of Association of the European Union are framework documents that do not contain a large number of norms that can be interpreted literally. And in this case, the court is facing this issue when it has to formulate its positions proceeding from the goals of the adequate regulation. In this case, the practice of the European Court of Justice exercises teleological interpretation. This method was properly revealed when applying versatile tariffs on railroad transportation. The court showed that it doesn't only accept the goals of the Union as an international bloc, but it also adopts the overarching principles of the functioning of the Union. The use of teleological method meant going to this goal of formation of the Union, striving to building a single market for goods, services, capital and labor resources within the Union. And it meant that the court was able to interpret the analyzed norm in such a way as to ensure the collection of a unified tariff for the carriage of goods by rail through the territory of one member state to the other. There was a pursuit of a deeper goal, ensuring or promoting the freedom of movement of goods. Professional athletes' case, in the light of the teleological methods of interpretation, is also important. The advisory opinion should be analyzed. The court, based on systematic interpretation of Clause 1 of Article 6 of the Treaty on the binding decisions of the Commission, and Subclause 1 of Clause 1, Article 39 of the statute, on the right of the member states to raise before the court the issue of the discrepancy between the EEC decision and the Union's law, concluded that the member states are obliged to comply with the decisions of the Eurasian Commission, and in case of disagreement therewith, they have the right to appeal against these decisions in the manner prescribed by the law, by the Union Treaty. Despite the fact that the Judicial Act refers to the systematic interpretation carried out by the court, it can be assumed that the legal position is also based on the desire to ensure the effectiveness of Union law as one of the manifestations of teleological matter. The position stated in the advisory opinion of December 2018 on the pension case that the level of human and civil rights and freedoms guaranteed by the Union cannot be lower than provided in the member states should be considered a big step forward. In fact, it is interesting to us from the viewpoint of interpretation, not only because the court formulates this proceeding from the supranational bloc's goals, but the establishment of this standard can become such a goal against which other acts of supranational law can be checked. It is believed that the use of the method of teleological interpretation of the law is important for the law enforcement practice of the EAEU Court. It has great potential, especially since the treaty establishes not only the main goals of the Union, but also the goals inherent in certain areas of regulation in the EAEU. At the same time, references to this method in the acts of the court should not be avoided. Ultimately, it is important that national courts and law enforcement agencies perceive not only individual legal positions of the court. The Vienna Convention is also highly important. Articles 31 and 32 of Vienna Convention contain the sequence of methods that the interpretation of international law must be subjected to. However, strict application of the Vienna Convention would mean the need, first of all, to understand the literal meaning of legal norms, then to assess their content in the context of the interpreted act, and only later to turn to the object of legal regulation and objectives of the relevant act. Meanwhile, the logic of integration law and the tasks facing the relevant court often requires the embedment of the sequence of methods of interpretation prescribed by the Vienna Convention and the use of teleological means, methods of interpretation instead of other methods. So let us ask a question: how come there is so liberal interpretation of the Convention? Well, the thing is, the European Union is not a party to this international treaty. To my viewpoint, it also largely to the fact that the Vienna Convention is not the very first act to stipulate the methods of interpretation. It is rather a codification tool for interpretation provisions that have taken shape stemming out of common practice, common international justice practice. An interesting, peculiar feature of the application of the Vienna Convention is the fact that in a number of cases its rules served as a tool for the EU court, with the help of which it distinguished between the norms of constituent treaties and almost identical norms of agreement with third countries. The purpose of such a distinction was to give agreements with third countries a different meaning in the light of their object and goals, and to protect the integrative legal order from interpretation based on the norms of acts, securing a lower level of integration. For the Eurasian Economic Union Court, such an approach is extremely important in the light of this context. It is known that many provisions or separate provisions of the Eurasian law are based on the WTO acts. And in this case, we're talking about things larger than the protection of the internal market. It's the trade in services and financial services particular, and a number of others. In this situation, it is highly expedient to look at the legal position of WTO dispute resolution bodies, dispute settlement bodies. Meanwhile, I believe that this approach should be applied with extreme caution. We need to look at the objective pursued by each and every of these international covenants. And we should take into account the fact that the genuine integration goals, genuine integration manifested in the operation of the Eurasian Economic Union could be different from the WTO goals. Thank you very much for your attention. Right, so let's continue.
We will give the floor to Anaïd Sarmatyan, the professor of the international law of the Russian Academy of Foreign Trade. The limits of interpretation of international courts is a guarantee to respect the sovereignty of the states. Welcome. We would be pleased to hear your presentation. Respected Erna, respected friends, very good afternoon. I'd like to express my gratitude, first of all, to the Secretariat of the Court for the efforts to prepare this event. I would say everything is organized in a perfect way, and I'm pleased to share my ideas and suggestions In relation to interpretation, in relation to sovereignty, probably I would be opposing to the previous speaker, because many ideas expressed by the previous speaker I find it difficult to agree with. Well, first of all, I'd like to say that so please do remember, recollect how the political map of the world looked like. As we have noticed the growth of island states and non-continental states diminishment, and then majority of the states have their representation offices in international organizations. They have diplomatic representation offices. They could file claims and then became sub-defendant, sub-claimant, so they acting as the subject of international law, and they find themselves at the tables of negotiations, negotiating with important countries of the world, and they're considered equal partners. Well, by the way, colleagues, you have to remember that many countries of these, where we see a political map of the world, they don't have any, they wouldn't say considered as stable sovereignty. In some of them, in some of these cases, the sovereignty is as initial stage of its development. So that we have examples of this kind of states around the Russian Federation. Then a question arises: what the small nations, what enables the small nations to act as equal partners, negotiators with important states? So we have to admit that no equality exists, and they would never have to take place. What enables the small nations to have the loud voice in the course of negotiations at international courts? If we compare about the voice expressed by the important states, so this international law enables the small states. It's classical understanding and perception. Even though listening to the speakers, it seems to me the classic received this negative connotation. I entirely disagree with this, because as it is known, and I would recollect the UN Charter, international law is embodied in the statute, in the Charter of the UN, proclaims the principle of sovereignty and equality of states. So actual equality does not exist, I would reiterate it. So, however, there is an arrangement, which has the force of principle, which is proclaiming sovereign equality of all states, whether they are small or big. And so this is huge achievement, I would say. This is civilization achievement, which many of us underestimate. We simply get accustomed or used to it, because when things we are accustomed to become boring. However, I would underline that international law, in its classic understanding, perception, ensures common, unique principle of existence of the states. It's important. First of all, because we have been looking at the post-Soviet space in the recent times. I would like to remind you, it seems to be important to me, that when we say the states, we do not refer to a certain abstract subject, entity. It's not a political institute, institutions. When we say the country, so we first of all mean the people that live at the territory of appropriate country. I would like to remind you that the source of the power of governments who sign international agreements and power of the members of the parliament, of the members that ratify these bodies, is the people. Because sometimes we do forget about it when we discuss and speculate about international law. This factor, in my understanding, is the democratic ground of the international law. As international law exists, is not for the states, for the benefit of the state, but it's for the benefit of people. And I would suggest that application of the law, including international courts, remember about it, so they do not forget about their responsibility to society. That's an important fact. I would like to remind you one more aspect, one more issue from the Charter of the UN, when it is stipulated that people of the UN are so decisive in creating conditions, ensuring that fair attitude, respect to obligations arising from the agreements and treaties and other sources of international law. I'd like to underline, dear colleagues, that issue of respect to obligations and liabilities arising from the treaties is so important that is reflected in the preamble of the UN Charter, and it's stipulated as one of the objectives of the organizations. Then the question arises, which and how the objective of respect to obligations and liabilities arising from agreements and treaties is ensured? The answer is very simple, because we could find the answer to the Vienna Convention about the law of international treaties, Article 31, 32 and 33. And I would remind you that the Vienna Convention does not provide for methods for different interpretation, as respected previous speaker stated. The Vienna Convention has only one rule of interpretation that is stipulated in Article 31 of the Convention. All elements that we see in the article, they are separate elements of the common rule of interpretation. When we interpret provisions of international agreement or treaty according to the Vienna Convention provisions, we don't have the choice, dear colleagues. We have common or unique algorithm of interpretation. It's only this which is expressing international consensus. In relation to other methods of interpretation, no international consensus is expressed or does exist. Seems to be that Vienna Convention interpretation is the only practical possible way of ensuring stability and ability to predict the international agreement. So, pacta sunt servanda, and the objective to arising from international treaties. So it's important today that we see unprecedented conflict of interests between the states, so that we look at the conditions that we live in has never existed before. Even in the Cold War, as I could compare with the awful situation that we could observe now, each state thinks about itself only. So the adherence to the law in these difficult times seems to me that sine qua non, there would be no other options to consider. What other factors promote or support this? As we could all see and understand, the international law stopped to be the means of restricting the behavior of the countries. So that's 100 or 70 or even 40 years ago used to be. Because in the previous days, the legal norms used to be the tool of elimination of conflicts and fixing certain compromise decisions, solutions, that the norm of the law has been expressing certain ability to solve. Now the objects of the conflict, the norms itself became the object of the conflict. It's due to this reason the focus of attention of the practitioners and scientists. There were issues of interpretation of international treaties and agreements. So through interpretation, the government and subjects try to protect their interests, making use of different arguments and technologies. If needed, the colleagues, let me reassure you, one may prove everything or anything. So you may be nicely, appropriately referring to different sources, proving two opposite points of view. This is easy. Accordingly, in this kind of conditions, dear colleagues, first of all, there goes instrumental perception of international law and application of it. International law is considered as instrument, sometimes the shield, the sword, to protect the interests of the states and other entities. It is exactly with this the flourishment of international courts is related, and the attention we pay to decisions they take. Indeed, if we speak about the decisions inter alia of the Eurasian Economic Union Court. But colleagues, I am entirely against for making an absolute judicial practice or court practice, because this importance value of the decisions of the court does not necessarily mean that international law should blindly adjust itself to practice. Not necessarily that we see through the solution of the court and the interpretation should immediately built into the system of international law and considered as legitimate. Well, it's easy, it's impossible to agree with it. Because at present, as I could see, the states should retain control over implementation and compliance with this negotiation or treaty liability. So its interpretation is possible through Vienna Convention as classical, considered by many. Only this type of interpretation based on formality, neutrality, fairness, only this interpretation ensures control over obligations and liabilities according to agreements. This is based on text. As we fall down into the zone of theological, evolutionary, value-oriented or any integrative interpretation, we seem to lose this control, dear colleagues, because at present, international consensus in international to the rules of interpretation is only limited to the Vienna Convention. In this respect, I have to touch such phenomena as integration law that we all are aware of, and it's a lot frequently mentioned. So what is international integration law? It's a kind of dark room where there are no rules and whatever can be done, because it seemed to be coming out of nowhere, and it seemed to be that everyone can do anything in this dark room. You can interpret the provisions of the EAEU treaty as one wants. Let me pay attention to the fact that I saw that the website of so there were contests for vacations, so that the requirement to nominees was they need to know the provisions of the treaty, so the law or the integration associations or international law. When we say or international law. So, colleagues, what does it mean? It means that the court itself pushed the international law backwards. It's kind of disaster, dear colleagues, because Eurasian integration, Eurasian Economic Union, is 100% the child of international law, and you have to remember it. So at the same time, the child forgets who the mother or the father are, and then think of himself as a superior creature. So phenomena of legalization of international law, when more and more fields are subordinate to international law and are regulated by this, results in a dangerous illusion that any problem can be and should be resolved using international regulation. It's a very dangerous approach, dear colleagues, because it may result kind of mistake or illusion that changing access to the international law, international resolution could consider be as regress. Any limitation of sovereignty is an achievement. So what we see as practical outcome, so this kind of, at the level of application of law, at the level of the practice of international bodies, on a regular basis, they're trying to push the ethical, social, and economic values are pushed into the international law provisions to make sure that they're legitimate, or to present as if they're legitimate, or their protection within the framework of international legal mechanisms and procedures. What it results in, then international discourse is shrinking. So there's confusion of the ideas of the value of rights based on ethics and their legal status. And in essence, this is coming into arbitrary rule and abuse of the international law in the course of resolving the international disputes. And then international law suffers, its authority suffers. Dear colleagues, let me remind you, today a lot was mentioned about the values, a lot of attention was paid to values. Let me remember that awful events, many awful events have been starting with pushing certain moral values. We all remember that what is ended in or with So the value path is a very slippery way. It's the way to hell, as I personally perceive it. I'm sure that the law should not become the utopia, moral utopia. The law, the law should remain the law neutral, unbiased, and objective. Because if this process we put question and we question the morale and there's many opponents, and then if this process the no return point can be passed or would be passed, first of all this would impact the countries that are of having no power in the sphere of economic, politics or military, because other countries would be imposing their values to other countries. It would be inevitable, and then principle of sovereign equality of countries would become a fiction. And then when we speak about, we refer to Joseph Brodsky, there would be end of the nice era. Thank you very much indeed for your attention. Thank you very much, as always. So very sharp, very precise, in a very smart manner, and then very interestingly. Thank you. We would like to give the floor the last panelist of the section, the first section, Yuri Lepeshkov, who is the Associate Professor of International Law, Faculty of International Relations of the Belarusian State University. So the topic for his presentation, the issue of expediency and possibility of the EAEU Court of the function of other judicial bodies in the Eurasian region. Good afternoon.
Добрый день, уважаемые участники конференции. Присоединяюсь.
Good afternoon, dear participants to the conference. I'd like to join the previous speakers and express gratitude to the Organization Committee and to the Court in general for the invitation and the opportunity to speak at this representative forum. Dear Erna has already voiced the topic of my presentation, so I would like to switch to the content of my talk right away. The Court of the Eurasian Economic Union is not the only international judicial body that operates in the Eurasian, or as the reference used to be until recently, post-Soviet area. As you know, back in the first half of the 1990s, so as to ensure the fulfillment of economic obligations within the framework of the Commonwealth of Independent States, the CIS Economic Court was established. In turn, the treaty on the creation of the Union State, concluded by Belarus and the Russian Federation in 1999, it provided for the creation of the Court of the Union State. The letter of the mentioned, the Court of the CIS Economic Court, despite more than 2 decades that have passed since the moment of its contractual establishment, has not been formed in practice, although the matter of the need of its creation is periodically raised, including at the highest level. Possible. As for the CIS Economic Court, it is probably undergoing one of the most difficult stages in its history, more than a quarter of a century old now. A vivid confirmation of this is the lack of completeness of the process of reforming this judicial body, lack of organizational and procedural completion of reforms. The current phase of this reforms has been going on for 5 years now. And another aspect I'd like to highlight is the absence of, over the past 3.5 years, the absence of judicial activity as such by this court. Essentially, the last decision passed, the last judgment passed by the CIS Economic Court dates back to April 2017. Its most recent decision on the dispute dates back way back to 2010. Taking into account the above circumstances, a completely logical, reasonable question arises about the feasibility, first of all, and the possibility, secondly, of the EAEU Court as the only actually operating international judicial body in the Eurasian area on a temporary basis, is it possible for the Union Court to overtake the functions of the Union State Court and or the CIS Economic Court, in the absence of the first of the mentioned and the actual failure to act judicially of the second one, meaning the Union State Court and the CIS Economic Court respectively. The posing of this issue is not purely theoretical. It is conditioned by particular practical considerations based on a clear understanding, and I believe all of us do understand the important role played by the judicial mechanism for resolving disputes and interpreting legal norms within the framework of interstate regional integration blocks or organizations. In this respect, I'd like to refer to this circumstance. The establishment and operation of the court, which is supposed to guard the foundations of integration, it is also developing the law of these international blocks. It is conceptually important for any interregional or any interstate integration mechanism. Another aspect that points at the feasibility and the possibility to take the decision of the kind, it is the fact that in the post-Soviet practice, there is a well-known example of this nature from the recent past. Particularly, I'm referring to the temporary functions. The court of the Eurasian Economic Community, the Eurosec court, the predecessor of the EAEU court, has been doing that for almost 8 years, particularly from March 2004 to December 2011. The CIS Economic Court basically bore this function. So the feasibility and possibility, 2 points I've raised before. Let's talk about feasibility or expediency at this time. So the expediency, albeit temporarily overtaken by the EAEU court of the functions of other courts in the Eurasian space, it is obvious. The expediency is there. So yes, it should be done. And the imposition of appropriate powers on the EAEU court, in our opinion, would make it possible to avoid the build-up of controversial issues, the piling up of situations in relations between the member states of the Commonwealth of Independent States and the Union State, of which many have arisen in recent years, as we know it. In terms of resolving this, settling these disputes, existing disagreements. In addition, the transfer of the functions of other regional integration courts in the post-Soviet space to the Eurasian Economic Union Court would contribute to the growth of the authority of this international judicial body, boost its expert capacity and competence, and it will boost its the demand for its services. Yesterday I had different opinions as to how popular or how much demand there is for the services of the Eurasian Economic Union Court. Somebody said that the Union Court was not in too much demand. Somebody said the opposite. Let's look at the statistics. I've checked out the stats that's available in the website of the court. As of July this year, I have found these figures: 55 applications, 11 from member states, 31 from legal from entities, 11 and 2 from the employees. So on the one hand, the court is in demand. On the other hand, I would not say it's too much demanded. Answering this question would require comparison of the EAEU court and other regional integration courts. For example, comparing it to the court of the European Union, the EU court is definitely in much higher demand, enjoys much higher demand. On the other hand, the Eurasian Economic Union is a different court in terms of number of member states in the underpinning integration bloc. European Union has 5 times more member countries by sheer numbers. So it's natural to compare the EAEU court with the EFTA court, and we will have the representative of the EFTA court talking to us, or the Benelux court. Before I spoke, as I was preparing my talk, I looked at the EFTA court website, and I wish to say that it is in much higher demand, at least currently. It has almost 2 decades on its caseload, so that's times more in the pipeline compared to the actual situation with the EAEU court. So the relevant question from my viewpoint is the demand for the services of for the EAEU court. The second part of the question raised in my presentation is the legal possibility of entrusting or empowering the EAEU court with the functions of the court of the Union State and or the economic court of the CIS. We should look into the constituent documents, into the articles of association of the considered regional integration courts. First of all, we should emphasize that both Belarus and Russia, the states parties to the Treaty on the Union State, are members of the EAEU. At the same time, 2 of the current 6 countries that participate in the agreement on the status of the CIS Economic Court are not members, that's Tajikistan and Uzbekistan. So to speak, they do not have their own judges in the EAEU court. On the one hand, this prevents the Eurasian Economic Union Court from considering cases in which the named states or entities with the corresponding nationality are a party or an applicant. However, on the other hand, this problem is easily dealt with by introducing a mechanism of appointing ad hoc judges from among competent representatives who are citizens of Tajikistan or Uzbekistan. Secondly, the legal opportunity. There is a conceptual similarity of the goals of creation and activities of all 3 above-mentioned regional integration courts. To save time, I will save you from specific wordings, but just bottom line, in the statute and in the treaty and in the mentioned agreement on the status of the economic court, the theme is the same, the keynote point is the same. The objective or the goal of establishing of these 3 judicial bodies is ensuring a homogeneous interpretation and enforcement of provisions of legal acts in the member states. Thirdly, it is important to note the fact that the subject, ratione materia and ratione personae jurisdiction of the EAEU court fully covers similar types of jurisdiction, which in accordance with the constituent acts are endowed with the other 2 aforementioned regional integration justice bodies. Concluding my presentation, taking into account the above stated facts, and also given the lack of any formal obstacles or prohibitions for the EAEU court to exercise the functions of other international courts, including on a temporary basis, the matter of possible legal mechanisms that could be used in such a case becomes relevant. And it seems to me that the model that has already been tried and true, found to be tried and true, early in the Eurasian region can be taken as the basis. Namely, the assignment of the CIS economic court's duties to the court of the Eurosec. In this case, the petition must be filed from member states founding of the CIS economic court. They should address the supreme body of the EAEU, the Supreme Eurasian Economic Council. In case of a positive decision of the latter, the conclusion of an agreement on this issue by interested blocs, organizations can be made possible. The treaty on the EAEU, the statute of the court will have to be amended, but it's not impossible because we've seen cases like that in the past. This is not a guidance that I'm outlining here. This is just my points for consideration that I would like to serve as food for thought to you. Thank you very much for your attention. Thank you. Thank you for your talk at our conference. I do hope that this is not the last time that we invite you as the speaker and have you talking to us. Thank you for the interest you've displayed into what the court is doing. Dear attendees, colleagues, we have run out of time almost completely, but we do have one question to be voiced before the lunch break. Mr. Alexey Ispolinov would like to ask it to Ekaterina Dyachenko as to the subject matter of her presentation. There have been several technical glitches, so I'll be voicing this question as it is, word for word. Ekaterina, how did you decide that the court is supposed to consecutively apply the methods of interpretation of Articles 31 and 32 of the Vienna Convention? And how come the court, according to your words, is relevant to the convention? Because the EAEU is not party to the Vienna Convention, or the convention codifies common practice, because common practice is, or precedent is mandatory. The floor is yours, and the mic is off. Yeah, it's advisable to turn the mic on. Still nothing. Right, so Ekaterina is having a hard time using her microphone. As we are dealing with it, it might take several seconds or minutes. Please bear with us. And running a bit ahead of time, I will say that after Ekaterina, once she has answered this question, there will be a break announced until 3 p.m. Minsk time. Then the second section will be announced, procedural aspects of the functioning of international courts and e-justice. We will have Nikolai Kulesh as the moderator, Registrar of the EAEU Court, and Kirill Entin, Deputy Registrar. Yes, the link, the sound is coming. Thank you, Mr. Ispolinov. Answering the first question, what I'm proceeding from when I talk about the consequential interpretation of the methods in Articles 31 and 32 of the Vienna Convention. First of all, these positions are maintained by the international doctrine on interpretation, and not just interpretation in the context of integrational blocks that, as I'm convinced, have some peculiar features. But there is also the issue of interpretation of classical courts with long-standing established practice. That's point number one. Point number two, what allows the European Union to digress from the word-for-word application of the provisions of the Vienna Convention. Let me again refer to the opinions of the scientists studying the EU law. They identify two key points I've been referring to. This is the fact that the EU is not party to the convention on the one hand, but the convention is not meaningless to it. It is definitely the key instrument, the key tool applied by each and every judicial body in the European Union. It contains invaluable material for interpretation. At the same time, the logic and the peculiar nature of the operation of integrational courts sometimes causes them to digress from precise application of the Vienna Convention provisions. I will make a caveat here. The Court of the European Union, whenever it's interpreting not the integrational documents, the constituent documents of the European Union, but the treaties with third parties, it follows the Vienna Convention logic. The special nature of constituent agreements and the interpretation thereof as well as the interpretation of norms contained in the secondary law. And even the particular nature of these acts, the multitude of this, the array of these principles, it also causes the interpretation methods to be transformed. Okay, thank you. Thank you for the answer. Yes, yes, I'm done here. Thank you so much. Thank you. Colleagues, the lunch break is announced.
Коллеги, большое спасибо.
Very good afternoon, respected participants. We are going to continue activities of our conference. And after lunch session is dedicated to procedural issues, issues of proceeding of international courts. Very often, these kind of issues are underestimated. The procedural aspects are considered as something purely technical, and they are counteracting to the essence. However, if we look at deeper, so we would be able to see that many procedural issues are related with the essence. It's exactly the presence of the clear proceedings of the court would be able to guarantee the equal attitude to the parties in the dispute, procedural aspects, and then presence of the proceedings rules would reinstate the violated rights. In particular, execution and implementation of the acts of courts. Today we live through a difficult time, so the epidemiological situation resulted in new challenges. Many courts and switched to administration of justice. That has been already noted at the previous session. It was not an exclusion that the Eurasian Economic Union Court has followed, which may say that a number of sessions have been conducted in the distant format with participants that went out of the courtroom. So therefore, I'm very pleased to welcome the wide panel of experts, and I would be happy to give the floor to our first speaker today, the regular guest of international conferences of the court, Michael James Clifton, head of the apparatus of the Hammerman Court in the Court of European Free Trade Union Association of. I'm very pleased to see you, Michael James.
Thank you, Kirill. President Bayashev, judges of the Court of the Eurasian Economic Union, distinguished guests, ladies and gentlemen. It's a great pleasure for me to address this conference again, and in the present circumstances, remotely. Before I begin, I must note that I'm speaking in a purely personal capacity, and that I must make clear that I do not speak on behalf of the EFTA Court. 2020 is proving to be a dramatic and tumultuous year in terms of political direction and public health. The year has had an impact and taken its toll across the world, across Europe, across the European Economic Area, the EFTA states, and the EFTA Court's seat, the Grand Duchy of Luxembourg. Today, I wish to address two main points: the impact of the COVID-19 pandemic and Brexit, and their impact on the EFTA Court, before turning to what I believe we, within the courts, must hold fast to, in particular in these times, upholding justice and maintaining rights. Turning first to the impact of the pandemic on the EFTA Court. Well, the EFTA Court has responded in a number of ways to the pandemic. These responses have been internal, procedural, and technological. Internally, the President of the Court, back in March 2020, decided to close the premises in light of the pandemic and the emergency measures undertaken by the Luxembourg authorities. This decision was renewed on several occasions. In late May, the President decided to reopen the premises partially as of the beginning of June. As regards procedural deadlines, on the 19th of March 2020, the Court decided, in light of the exceptional circumstances caused by the outbreak of COVID-19, to prolong the deadline for submission of written observations under Article 20 of the Court statute from 2 to 3 months. It decided to revert that deadline back on the 26th of May as of the 1st of August. Now, this was quite unusual, and it's the first time that such a time limit set on the basis of the court statute, as opposed to its rules of procedure, has been made. On the 27th of October, the President of the Court decided to impose stricter preventative measures for the time being and strongly recommended that everyone work from home unless presence of the office is essential for a particular task, and that remains the state of play today. In light of the closure of the court's premises, as well as the COVID-19 related travel restrictions, including quarantine periods across Europe, the EFTA Court has adopted two distinct procedures for those cases in which an oral hearing would have been scheduled: a supplementary written procedure or a remote hearing. Supplementary written submissions were used in cases E1019 Bergman Action Gesellschaft Kitzbühel and in E1319 Hartplaat. The court, having consulted the parties, decided to dispense with the oral proceedings in accordance with Article 97.4 of the Court's Rules of Procedure in the current extraordinary circumstances due to the coronavirus pandemic. Instead, it issued measures of organisation and procedure to compensate for the lack of an oral hearing by providing the parties with the opportunity to provide supplementary written submissions, confined to the scope of what would have been presented at an oral hearing. Further supplementary measures of organisation and procedure may subsequently be issued should the court have questions to put to the parties in those cases, but that wasn't done. The second option was that the court began to conduct remote hearings, and the court's very first remote hearing was held on the 16th of June in joint cases E11 and E1219 ad publisher. A second remote hearing was held on the 7th of July. These hearings, as with today, were conducted over Zoom, with the judges and the registrar robed and sitting in a socially distanced fashion in the courtroom. Remarkably, these hearings were also streamed onto the court's website to ensure that the proceedings were conducted publicly. This is a first for the European courts, whether the EFTA Court or the Court of Justice of the European Union. And to date, the Court of Justice of the European Union continues to hold hearings and is yet to embrace the remote hearing concept made possible by technology. The court has issued guidelines for participants for the conduct of these remote hearings, and they're subject to the same rules as generally applicable to ordinary hearings, oral hearings before the court. However, counsel are expected to wear business attire rather than court dress, and while the President directs the conduct of the remote hearing, the technical control is undertaken by an administrator who, under the President's direction, activates or deactivates the microphones and cameras. And actually, the ability to deactivate the cameras of those not pleading was one of the reasons why the court settled upon using Zoom as opposed to other software or platforms. As with physical oral hearings, pre-hearing preparatory meetings are held between the counsel or agents and the judges. These preparatory meetings, whilst on Zoom, remain private and are not streamed, and they also provide an additional practical function in checking that all the technical equipment is working properly before the remote hearing itself begins. A transcript of the proceedings is prepared for subsequent internal use, as is usual with our court proceedings. And the first two fully remote hearings were a great success. And this led to more or less a default position, being that remote hearings would be used this autumn. Now, while we have had some technical difficulties, including breaks in individual connections or the stream itself buffering repeatedly, these problems have been resolved by on-site technicians during short breaks in the hearing itself, or in the preparation for subsequent hearings. By Christmas, we'll have had a further 5 remote hearings, and the supplementary written procedure mechanism, that hasn't been used again because it didn't prove effective or as efficient as anticipated. And slightly differently, we may actually expect that certain judgments may be rendered and streamed on the court's website before Christmas too. These remote hearings and their streaming are an undoubted technological leap and perhaps transformational. It's too early to assess their long-term effectiveness or whether they may supplant ordinary hearings in the future. Nevertheless, the ability to stream hearings truly opens the court's proceedings up to the world. The stream of the court's hearings is being picked up by third parties, including the Norwegian legal news website RET24, which has streamed the remote hearing in case E820 criminal proceedings against N. The courts may also consider streaming ordinary hearings in the courtroom to the court's website when the public health situation permits. And the court has invested in that regard in more sophisticated equipment to be used in the future, including ceiling-mounted cameras and large screens for the participants to appear on before the court. Now, turning to my second topic, the impact of Brexit. On the 31st of January 2020 at midnight, the United Kingdom left the European Union. The United Kingdom was, in its own right, a contracting party to the European Economic Area Agreement, the EEA agreement, in the EU pillar of that treaty. The government of the United Kingdom and lawyers authorised to practice before a court of the UK have appeared regularly before the EFTA court over the years. Article 63(1) of the EEA-EFTA separation agreement, signed by the UK and the EEA-EFTA states, that's Iceland, Norway and Liechtenstein, on the 28th of January, provides that before the end of the transition period, a lawyer authorised to practice before the courts of the UK represented or assisted a party in proceedings before the EFTA court or in relation to requests for advisory opinion referred to it before the end of the transition period. That lawyer may continue to represent or assist that party in those proceedings or requests, and this right shall apply to all stages of the proceedings. The technicalities of the EEA-EFTA separation agreement and its interaction with the UK-EU withdrawal agreement are really quite intricate. For the purposes of today, I just want to really focus on one point in particular. So the court has necessarily introduced procedural rules to implement this new treaty. But paragraph 1 of Article 1 of Protocol 9 to the Surveillance and Court Agreement, this is the new protocol that's been added on as a result of Brexit. It provides that the EFTA Surveillance Authority and the court, for the duration of the transition period, which is until the end of 2020 unless extended, but that's not happening, that the EFTA court would continue to have jurisdiction on this side of the agreement. But the provision was only extended provided that the EFTA states continue to treat the United Kingdom as if it were a member state of the European Union for the purposes of the EEA agreement until the end of the extended transition period. In other words, if the transition period had been extended, it didn't appear necessarily automatic that the UK would be treated as a member state of the EU for the purposes of this treaty by the EFTA states. Now, the consequence of these various amendments is that during this transition period until the end of the year, the UK remains able to appear before the EFTA court. And slightly differently, lawyers authorised to practice before a court of the United Kingdom remain able to represent parties in cases brought before the end of the year, and this right has been exercised, for instance, in the pending case E1220 Telenor and Telenor Norge. Most recently, indeed just 2 weeks ago, the ambassadors of Iceland, Liechtenstein and Norway signed an amendment to the Surveillance and Court Agreement. And this enables both the EFTA Surveillance Authority and the EFTA Court to monitor the implementation and the application of the separation agreement. Now, this is quite interesting because Article 1 of that amendment provides that the powers of both the EFTA Surveillance Authority and the court that follow from the EEA agreement and the Surveillance and Court Agreement shall apply mutatis mutandis. And this actually is the very first example of the concept of docking of agreements that I addressed this conference on last year. Thus far, 2020 has been really evolutionary for the EFTA Court. Significant and substantial procedural changes are afoot or have taken effect, and the impact of Brexit itself is some time away from being fully appreciated. The COVID-19 pandemic has affected significantly how the court operates, and the response in terms of holding remote hearings in particular may prove the basis for long-term changes as to how justice is delivered at the European level. In that regard, I must note that irrespective of the pandemic and irrespective of the political convulsions this year, it is the obligation upon the European courts, the judges and the lawyers who work for them, to cleave even tighter and more firmly to justice. And I feel the similar views are held by those here. Justice must be done and seen to be done. And this is the rationale behind the EFTA Court's remote hearings being held and made public through their streaming. And I commend the organisers of this conference for ensuring the continuing free exchange of understanding of the law in action, both in the current international climate and indeed having regard to the current political strife in Belarus. I'd like to conclude on an aspect of comparative law. The European courts, the Court of Justice of the European Union and the EFTA Court, are often thought to be creatures of their respective member states and of the treaties they have contracted. To that end, the EFTA Court is normally thought to have no inherent jurisdiction to dispense justice beyond its treaty confines. And I have to say, this is a view I have shared until recently. However, to my mind, as these jurisdictions have evolved, they've relied on and expanded on certain small points in their treaties to protect rights and ensure justice. Professor Mark Entim and Dr. Vadim Vonyakov wrote last year that the issue of human rights has not been reflected in the competence of the Eurasian Economic Union. It is completely the responsibility of the member states. They continued, special attention should be paid to the issue of ensuring the observance of human rights in the implementation of the legislative process within the EAEU. Human rights are not mentioned in the Treaty on the EAEU. However, the imperative of their observance is enshrined in the constitutions of the member states and international treaties. In this respect, it would be important to invite the Court of the Eurasian Economic Union to clearly speak out about the place and role of human rights in the EAEU legal system. Now, I cannot speak on the interpretation of EAEU law, and that is, of course, for those here, and on the basis of cases brought before the Court of the Eurasian Economic Union. However, I note the wording in recitals 2, freedoms of man and national, and 9, objectives and principles of the United Nations Charter and other universally recognized principles and regulations of international law, as well as Article 4, to improve the living standards of their population included in the treaty. And I'm basing myself on the courtesy version lodged with the courtesy version in English lodged at the UN. The EFTA Court has grounded its application of fundamental rights, although initially considered innate, upon only 2 words in the first recital to the EEA agreement. The Court has taken the position that the provisions of the EEA agreement are to be interpreted in the light of fundamental rights, and the provisions of the European Convention of Human Rights and the European Court of Human Rights' own judgments are important sources for determining the scope of those fundamental rights. This is rather parallel in conception to a doctrine in Irish law of unenumerated rights. Article 40 of the Constitution of Ireland provides that all citizens are to be held equal before the law and obliges the state to vindicate the personal rights of the citizen. The term personal rights, as interpreted by the Irish courts, has led to the recognition and vindication of many rights not expressly provided for in the text of the Irish Constitution. And these unenumerated rights include the right to bodily integrity, the right to marry, and the right to earn a living, amongst others. Ladies and gentlemen, the tumultuous events of this year have revealed once more the fragility of societies, and we will be judged by how rights are maintained and justice is upheld. I commend President Bayeshev and the judges of the Court of the Eurasian Economic Union for holding this conference and including the role of basic human rights in interpreting EAEU law in session 1. And I leave you with my thoughts based on comparative law. Thank you very much indeed for your attention.
Thank you very much indeed, Michael James, for this interesting talk. Indeed, the topic of human rights and the necessity to interpret the EAEU law with respect from the viewpoint of fundamental human rights and freedoms has been touched upon during day 1 of the conference. Today, in the first session, pre-lunch, we also had the possibility to revisit this topic. So indeed, over the past several years, regardless of direct codification of these rights and freedoms in the legislation on the Union, the Treaty of the EAEU, the overarching principle was formed, maintaining high level of protection for these rights, safeguarding these rights. I would also like to note that Michael James's presentation touched upon 2 conceptual points, particularly important points. First of all, this is the necessity to ensure for an international judicial body some flexibility, ensuring some flexibility when applying or in some cases modifying, adapting the procedural norms and rules. The presentation basically showed how the EFTA court, based on certain regulation provisions, was able to adapt and modify its procedures the way it saw fit and necessary. The thing about written evidence or written materials and oral hearings. Also, there is a necessity to ensure conceptual points of administration of justice regardless of external circumstances, as harsh as they may be. And in this case, even regardless the use of e-hearing, it was possible to use the broadcasting facilities to not abandon the principle of transparency, of public nature of proceedings. Our next speaker is the Associate Professor of the Moscow State University, Department of International Law, Olga Kardasheva. She'll be talking about the issues of application of pre-trial settlement in the resolution of disputes of the Court of the EAEU. Olga, you have the floor.
Добрый день, уважаемые участники.
Very good afternoon, dear participants of the conference. I'm pleased to welcome you all, and I would like to express my sincere gratitude to organizers of the conference for the opportunity to take the floor and deliver my presentation. Now I'm going to share my presentation. Well, as it was mentioned, my topic is issues of application of the pre-trial procedure of consideration of the core disputes in the EAEU court. Well, the state creating international courts try in one way or another to foresee the degree of various control. These mechanisms ensure the states against appearance of undesirable judicial practice. In addition, they limit the categories of disputes and restrict access to individuals by these. The courts of the European integration, it was not any exclusion that the claimants, only legal entities may file claims and individual entrepreneurs, provided they pay the dues, and then the individuals could be acting appeal against the inaction of European Economic Commission that are directly involving and touching the rights and legal legitimacy of the applicants. One more requirement was the compulsory pre-trial consideration of the cases in the European Economic Commission that was, first of all, appeared in the filing application to the EAEU. Talking about the world experience of the pre-court or pre-trial dispute settlement, one may notice that for the international procedure, pre-trial consideration of disputes is not fixed as compulsory pre-trial. It was fixed as compulsory pre-trial procedure of consideration of the case, like counseling or mediation of the procedure of in the World Trade Organization, as well as optional procedures like mediation and International Center of regulating the investment disputes. Other ways of consideration and mediation just independently could be applied as well as pre-court specific study. It is considered that free, say, good services, mediation and then reconciliation procedure. Alternative nature of this can be established by the parties, but offering the compulsory nature, making sure that should be stipulated in the document that is regulating the activity of international court. Article 4 of the filing application to the Court of the Eurasian Economic Community of the economic entities established that the application is considered by the court only following the preliminary application to the Commission of the Customs Union by the economic entity. The Economic Entity Court, this requirement worded in a different way. Dispute is not considered by the court without preliminary application of the claimant to the member state or commission for resolving the issue in pre-trial or other ways. So this was declaring not only compulsory nature of the procedure, but the objective is pre-trial settlement that was allocated not on 2 months, but 3 months. So this provision of the statute speaks about two conditions where the dispute could be considered, and the presence of the dispute itself and compulsory application to pre-trial mechanisms of its resolution. In case we speak about the second issue, there are certain so the court of the EAEU has never expressed itself, proceeding from the fact that the presence of the application and then objections on the part of the claimant speaks about the presence of the dispute itself. So the right of the applicant to the court is limited by its obligation by settling the court pre-trial manner rather than appealing against action or inaction. Exception is the case directly stipulated by the agreement or treaty, which is application to appeal against about violation of general rules of competition at transboundary markets, which is considered without any preliminary application in the pre-court trial consideration of the case. It is necessary to note that unlike limitation of access to the court, which is of objective nature, application of which has causing no doubts, in the pre-court matter, it's combination of objective and subjective factors. And then subjective nature means that the court needs to evaluate the efficiency of the process. In this respect, this limitation is a very finite instrument which requires, if not agreement, coordination, that at least understanding and non-contradiction of the Eurasian Economic Commission and the court. So we speak about, first of all, about coincidence of the representation of the objectives and the tasks of the pre-court consideration. Practice, unfortunately, practice of the pre-court pre-trial procedure in the Eurasian Economic Community courts and then the Court of the Eurasian Economic Union. So the commissions and the court have different approach, drastically different, which is definitely impacting the predictability and expectations of the potential applicants, and in the long run, the efficiency of the system of dispute resolution on the level of the EAEU. The rule was the requirement of the pre-trial procedure of consideration of the cases cannot become compulsory and should not be applied automatically So not to violate the norms of high level, the principle of equality of the parties, or the right of the applicant to the access to court. The doctrine also represents the point of view that the pre-court settlement is the similar of the exhaustion of the internal tools of protection, which is actively used by the European Court of Human Rights. I'm not sure whether this is correct or appropriate, because this practice, in our understanding, definitely shows that pre-court settlement is the component of the court proceedings in the broad sense of this word, and the efficiency depends on the interaction between the court and the Commission. The institute of the pre-court settlement of the disputes cannot be qualified as the objective for efficient execution of rights for individual approach or application. Rather, it is one of the elements of the procedural procedure established by the law of the Union that parties of the dispute has to comply with, and without compliance to which the court has not the power to consider appropriate case in essence. Pre-court settlement of the dispute is the form of protection of the violated right, which results in the attempts of the parties to regulate it independently prior to the court is considered, the case is considered by the court, with positive outcome of which there is no necessity to approach the court. Only in the case one disputes disturbances are not regulated by the parties, the appropriate dispute of the economic entity can be considered for consideration of the court. So therefore, respect or compliance with pre-court settlement is the appropriate condition of the appropriate implementation, exercising rights for putting a claim. Before, say, in case the so there is no sense of this procedure in case they state one thing and then say the other, because the kind of requirement will have to spend 3 months in the course of consideration before. It's important to speak about the necessity of the disclosure at the stage of pre-court settlement of all the arguments to justify the requirements they settle. In order to provide for maximum efficient consideration of the court in the pre-trial, avoid settlement of new requirements which were not subject to consideration of the court. That would violate the rights of the Commission as the party to consideration of the case. In addition, the court a number of times mentioned about the necessity to prove the violation of the rights and legitimate interests of the economic entities and entrepreneurs. The most disputed was the approach of Eurasian courts in the issues of pre-trial settlement because of the inaction of the Eurasian Economic Commission. So they unexpectedly interpreted the procedure of private individuals approaching the court about violation of their rights and obligations and interests. And then the Eurasian Economic Union Court, in one of its decisions, stated that any of this kind of statements should definitely be subject to consideration by the Court of the Union. In this respect, private individuals' application to the Commission is considered by the Court as sufficient ground for the pre-court trial settlement procedure application. According to the practice of the Eurasian Economic Union Court, within the framework of the claim against inaction, negative attitude of the Commission can be considered inappropriate if the negative evaluation of the actions of the individuals is the obligation of the Commission. Interests of with the joint stock company Translogistic Consult. This case was considered by the EAEU court, referring to the opinion that it was the case of Tarasik. Individual Entrepreneur Commission negatively evaluated and did not reflect the results of the work conducted or done. So therefore, collegium or chamber of the court negatively considered this as inactivity or lack of activity. It's necessary to clarify the position of the court in relation to arising and existence of the court, not in the process of consideration of the case, but prior to application of the claimant to the court. Only this kind of approach would ensure that appropriate mechanism is used. The problem of TLK, as I mentioned, that the entity approached Eurasian Economic Commission requesting to legally evaluate the customs decisions procedure of decision taking at the level of the Eurasian Economic Commission that classify the commodity they refer to. Nothing in the letter stated at the presence of the dispute with the Commission rather than the dispute itself has arisen because of the inaction of the Commission, and then after the response of the Commission was provided, the TLK did not agree with. Therefore, the major argument of the Commission was that dispute per se, as it was mentioned in Article 43 of the Statute of the Court, by the time of application to the Commission, has never existed. The very fact of presence or absence of the request for pre-trial is a secondary and is not, is not enough grounded. So, situation with pre-court settlement is kind of source of friction and between the two supranational institutions that should be allies per se. Approaches of the Commission and the Court differ sometimes in a very radical way, so that definitely impacts negatively the legal certainty and predictability. So that ideas of pre-court trial as a similar thing using the exhaustion turned to be very attractive to be used as instruments. And even at present, supported by the Union, by the Court of the Union and certain judges. If we look at the case of TLK, not only from the point of view of the Human Rights Court, which applicants file complaints against the action or inaction of the state, it's clear from the point of view of protection. Take into account the subsidiary role of human rights courts from the point of view of International Court of the UN, then the whole situation with case of TLK and claim of TLK would be considered in a different way. Absolutely. Speaking about the legal nature of the procedure of compulsory pre-trial settlement of the case filed to the EAEU court, first of all, we need to mention that this requirement is only applicable to the cases filed by individuals, but also interstate claims filed by states. So should not be used as the reason the tools were exhausted. So they should find out the objectives and the reasons the states apply using because they envisage this only for private individuals, and then in the statute of the EAEU court they expanded it for different parties so probably the best idea to look at the practice of the UN court rather than the European Court of Human Rights, which regularly faces with requirements and stipulated in agreements of compulsory nature of use of the various pre-court settlement procedure before court is considered by the International UN Court. UN International Court, in case they decide about the limits of their jurisdiction, always establishes the presence of the court between the parties. Say, very recent case of dispute between Russia and Georgia, International Court is taking tougher and tougher positions, getting away from the classical definition of the dispute in the famous Mavromatis decision. In the modern perception of understanding the International Court of the UN, the key issue to admit the presence of the dispute is the parties have to have legal positions that are contradicting, which means that if the claimant disagrees, positive opposition with the defendant. Senegal case was the first time when the court disagreed to consider because there was no dispute between the parties. In other words, International Court of the UN proceeds from the position that presence of the existence of the dispute envisages that the very fact of the existence of the dispute and the content of the dispute should not be a surprise to the defendant as the case is filed to the court. A quite categorical position in relation to the requirement about the compulsory nature of pre-court procedures stipulated in various international agreements. In the case Georgia against Russia, International Court of the UN expressed the requirements about compulsory procedure of pre-court or pre-trial settlement, so they have to be respected because they perform three functions. It's a notification about the existence of the dispute, determine the subject and the parameters of the dispute, push the parties to find file amicable solution without application to the court, and determine the parameters of consent of the countries for the jurisdiction of the court. What I would like to say in conclusion, the problem of pre-trial consideration of disputes cannot be considered without taking into account the procedure objectives and the desire of the parties quickly and efficiently consider the dispute. Pre-court settlement should not be limited to narrowly technical consideration and stage of the case. The principle of competition should not be used in the reduced manner, only as opportunity for the party to freely represent their arguments, as the right of the opposing parties to disclose the arguments and proofs prior to the court consideration is the necessary element of this particular principle. Practice of application of the existing pre-court or pre-trial settlement revealed definite contradictions between the institutes of the Eurasian integration in understanding and perception of the role of this procedure. So pre-trial procedure is compulsory and independent stage of consideration of the case or dispute, which should be reflected in the legal norm, fixed, applied and interpreted. Analysis of existing international legal acts arrives to the conclusion that the law of the Union establishes compulsory requirements to preliminary procedure of pre-court settlement. However, there is no mechanism of revealing disputable issues and its transfer to the stage of pre-court settlement of the dispute. In this respect, it is necessary to modernize legal regulation of pre-trial consideration of the disputes as independent stage of consideration of the cases in the EAEU court, which result in a more detailed regulation of this procedure. Inter alia, limitation of the range of subjects, as well as filing additional arguments and arguments at the consequent stages of consideration of the dispute, and building constructive dialogue between the integration institutes or institutions. Thank you very much for your attention. Respected colleagues, again, once again, thanks for the opportunity to take the floor. Olga, thanks very much indeed. Thanks for the very interesting presentation, and indeed we would be happy to publish it in the collective book of the presentations and materials of the conference. I would like to note, however, the fact that requirement to comply the pre-trial procedure is unique, irrespective of the entity that files, whether this is the member state or whether this is economic entity, and to establish the same requirements to the economic operator to go through pre-trial procedure, take into account the standards of the UN International Court, probably would be placing quite heavy burden to the economic entity. It's not quite clear then why the economic operator should send a copy of its application to the Eurasian Economic Commission before, as they knew it before. So in fact, in my own view, if you look at the theological interpretation of aspects of the pre-trial settlement procedure, to me, it's an opportunity for the economic entity and the Commission to agree upon and to persuade each other, to persuade the Commission in the appropriate position of the economic entity. This is exactly the difference in the sphere, between the sphere of competition, where filing an application to the court is preceded by an opportunity for this economic entity in the course of the exchange of opinions with Commission, so to persuade that they have not done anything wrong, so there was no violation per se. The same happens in the course of pre-trial settlement in relation to action or inaction. It's very often the attempt of the economic entity to persuade using all appropriate possible available methods so that inaction is wrong or decision should be repealed, so that's not necessarily legal arguments are used. They would use economic and political expediency. However, this is a very interesting issue to be discussed, to be debated, and I hope that we will be able to come back and discuss it. Now, now I'm very pleased to give the floor to Alexander Naumov, head of the Department of Organizing and Monitoring and Courts and Legal Department of the Eurasian Economic Commission. Probably he is the right person, which best of all knows and be able to describe from inside how interests are introduced and presented in the Court of the Union, because I was pleased to see him, to witness to his presentations. Alexander, the floor is yours.
Good afternoon, the High Court, the participants of the conference. The right to determine the competence of the court is very important when pleading to the EAEU court. I believe that prior to going to court, the applicant must study the competence of the court and determine that this is the court is the very body that can restore their violated rights and justice, and not to consider the court as the last straw that the drowning person is clinging to without exhausting or without having exhausted the remedies domestically. And they just treat the court as the next instance to regulate the dubious situation. As for the competencies, this matter has been raised during the conference, and there are various standpoints that need to be looked into. Yesterday, in the course of the conference, it was mentioned that there is an issue of customs representatives, if they can go to court to say, President Baishov pointed this out, whether the customs bodies can go to court to protest the omission or alleged omission of the EEC. This is a tough process. However, it causes us to look at the statute on the position of economic entities. If there is no subjective or essential competence of the court, the case can be dropped because of various items of the statutes of the court. As for the quality of the court's competence, I would also elaborate that there is another important point. The cause and effect relations must be established between the actions or omission by the Commission, the rights of the claimant, and the consequences they suffered. So right now the case is moving forward, the things are moving forward. Today's opening of the conference, yesterday's sessions, it showed that who is coming to court, why they're doing so. It's not just stipulated in the statute and it's mandatory to be adhered to in the narrow sense of the word. That any person can go there for any matter, to bringing any matter, any case. And in this case, the EEC will be the defendant, and the court is supposed to consider any claim from any stakeholder. And indeed, given that the matter or the question that the judges that claimants bring a case to can be different, and this the duration could be different, could be long. Erna today identified in her presentation another important criterion that is governed by the EAEU law, and it can cause the economic operators to resolve the issues of interaction with the Commission without going to court. So it's about the statute of limitations, basically. There must be a certain time frame during which the claimants can bring the case to the court if they see their rights or if they believe their rights have been violated. So indeed, the statute of limitation of actions is necessary. It's a good thing that we have this message on the table. It deserves attention and implementation. As Alexei Ispolinov mentioned today in his presentation, the court and the Commission must be partners. The court must not consider the Commission as an eternal defendant. There must be specific timeframes for procedures. This suggestion for the statute of limitations during the process where claimants bring a case to the court, there must be some reasonable timeframes, both for bringing the case to court and for the defense. Thank you very much, dear Erna, for the suggestion that you've basically put on the table. Day 1 and day 2 of the conference go to show that both the attendees and the followers of the conference are interested in the circumstances changing around them. So, having heard the question on the statute of limitations today, we want more. We need more. We want more. Using the opportunity to address to the court, I would like to mention something on the competence of the court. As mentioned throughout the conference, the objective of the court is homogeneous or uniform application of international law, treaty of the Union, and other blocks legislation to the well, basically it's a fair consideration of points. The court determines or handles the dispute as per the claim of the claimant, where the interests of the claimant have been infringed in entrepreneurial activity, other activity, if such decision or its provisions have been violated the rights and the legal interests of the economic operator. And the second point I wish to emphasize is that courts can debate on the action or omission of the Commission. They can test it in court, in entrepreneurial or other types of economic activity, if such action or omission have resulted in infringing the rights that the claimant is eligible to under the Eurasian or international law. So the big question that we have right now is considering the cases about the omission or inaction of the Commission. Right now, there have been several cases considered by the court, again against the omission or claiming the omission of the Commission. Omission is technically a failure to perform by an official that he or she could have or should have performed because of the duties they performed. I would also like to note that the initiation or the onset of omission is when three circumstances come together. The official must perform something, they can perform it in the circumstances around, and they are required to do so. Ergo, the competence of the court is not handling any dispute on the mission of the Commission, but only for the requirements. The dispute arose out of the implementation of the 2014 Treaty on the EAEU, or international treaties of the Union, or the norms of the Union. Claims against the omission of the Commission. At the same time, I wish to point out that such omission of the Commission must directly infringe the interests of economic operators in entrepreneurial other economic activity. The rights must be enshrined in some treaty or some piece of legislation in the Eurasian Union. And these interests have been infringed. It is assumed that the rights of the person or entity have been violated when there are adverse consequences for it or for them. They must be actual and essential. There must be a cause and effect relation to the omission of the Commission. They cannot be fixed otherwise than through legal proceedings in the Eurasian Court. The claimants often disputed the decisions of the court, or contested the decisions of the court about the Commission. The claimants rose the issue of omission by the Commission. The Commission believes that the disagreement of the claimant alone is not enough to hold the Commission guilty of omission. So the appropriate consideration of this matter would mean identifying the responsibilities of the Commission when handling specific claim by a particular claimant and the facts therein. As per the request of Member States, from legal entities, there is a clarification of 2014 The requests must be registered by the Commission. They are considered by departments in the prescribed order. The Commission handles the requests from individuals and legal entities. The feedback is provided in the time frame of specific number of calendar days from the time of registration. Fortunately, the sound is not particularly good. So, if we're talking about violation of or infringement of claimants' rights and interests, in virtually every case, the claimants' rights were violated not at the time of application to the Commission, but before that, as a result of action or omission of national bodies, and the assessment of those action or omission was given by the national bodies. The Commission cannot reconsider or overturn individual decision of state bodies, of EAEU Member-States and judicial bodies. The analysis of the validity of these documents that state bodies and judicial bodies pass has been the emphasis of the Commission. I'd also like to note that the Commission is not competent to establish facts already established in the judgments of judicial bodies. I'm happy to see that within the framework of this conference, the practical matters have already been reflected in a number of talks and presentations by respected colleagues before me. Olga today, Olga Kadышeva, who spoke just before me, she touched upon a very important point, a pretrial settlement, exemplified by the omission or inaction, failure to act. So she considered what the criteria could be to look into the maintenance of the court procedure, whether it was maintained. Yes, in practice there are cases like that, where the Article 43 of the statute, sometimes the court considers cases without pretrial settlement, or there is a requirement for pretrial settlement or attempt to do so. Nobody is going to deny the fact that a mandatory prerequisite for the claimant to come to court is the use of the mechanism of pretrial settlement before doing so.
Осуществляется комиссией в порядке утвержденного решения коллегии комиссии от 19 марта 2013 года номер 46 с учетом положений пункта 43 и 44 статута суда. На практике можно сказать, сложилось...
Essentially, we can say the following. In practice, there is this notion, or there is this perception, that the claim of the claimant alone to the Commission to look into the facts or to investigate the instances or action or omission of state bodies or judicial bodies that the claimants disagree with, and take measures of pre-court settlement, pre-trial settlement, although there was no dispute at the time of application between the applicant, between the claimant and the Commission, because it was the first ever application to the Commission. So Olga touched upon this matter as well. I'm not reinventing the wheel here. This is the case. Accordingly, if the economic operator comes to the Commission and he brought specific questions and he failed to get the result expected, that does not mean, or this does not suggest, that the Commission's response to his request can be deemed omission on the part of the Commission, with all the consequences to be borne in such case. In other words, it can be noted that, as I mentioned, we are considering the applications coming in according to the regulation on the Commission's operation. The claims that are responded to, if the claimants disagree with the answer or with the response, they can automatically be deemed omission. If there are cases of taking claims to the court, in these cases the court is looking at the answer, or at the judgment, the ruling. However, the claimant does not agree with this judgment, and the court considers the validity of such ruling or judgment. Unfortunately, there is a lot of background noise. Something about the competence of the Commission, of the abstract nature. Is there life on Mars? What kind of measures can be taken by the Commission in case there is an alien invasion? So what are we supposed to be guided by? Legal omission as the form of legal behavior, or I believe that the topic on the so-called negative responses by the Commission or negative judgments by the Commissions not in favor of the claimant requires further research, further investigation, so as to rule out the instigation or to rule out the commencement of the processes that generate this vicious cycle. This is a harmonious implementation of the rights, application of the law, protection of the interests. Olga again mentions something I'm about to refer to now. The claims brought to the Commission must be reasonable, must be similar to the claims brought to the Court. If there is an amendment possible, so where is the border, where is the line that we can not cross, should not cross when amending these rulings or judgments? So what kind of pre-trial settlement are we talking about here? Another issue that Erna has touched upon today, and this is important, when the claimant came to court, when they got the answer from us, from the Commission. We will develop this idea. I believe the statute of limitations is meant, so I hope for further support in this matter. There is an airplane landing in the background. So, how well was the claimant able to reflect in their claim the norms allegedly violated by the Commission when preparing its ruling or action or omission on the part of the Commission? These statements must be clear. Yes, indeed, the customs code or some other provision of the EAEU law is violated. This must be itemized as specifically as possible. Also, specialist experts should be part of the hearings. It's a matter of procedural execution of their status if the experts are brought on board. Indeed, there are cases with involving remote hearings. There is a particular benefit yielded from that. The status of the experts is important. To this end, we require procedural implementation. We support the idea of remote court hearings. There is a matter of technicality or technical features. So authorizing the powers of the representative, getting the materials in a secure way. These points require argumentation, and we can do all that. We can handle all that. Another point to bring up: yesterday and today, there's special opinions and minority reports by the judges, and basically there are many unresolved questions, many matters still to be investigated, researched, and that will mandate and warrant further amendment and enhancement of the Eurasian law. On our side, on our part, we are prepared to cooperate, and we hope that this feeling is mutual. Thank you for the possibility to speak on the issues suggested. Thank you very much, Alexander. Thank you for the interesting and saturated talk. Indeed, for the Court of the EAEU, for the Commission, it's an important partner. The Commission is definitely not considered by the Court as the perpetual or eternal defendant. It is advisory opinions that have allowed to elaborate principial or conceptual standpoints by the Commission. We've cooperated on that. Strategically, we've seen many points of empowering and expanding the powers of the EEC. I would also point out that indeed we have the situation when action or omission or failure to act is a unified category. Omission per se, well, does not sound strikes a bad chord, but strictly legal. Yes, omission does not have the negative connotation in the legal sense of the word. There was another important point raised by Alexander. It's a matter of revisiting many claims. Many cases brought to the Commission arise from disputes of economic operators with various domestic bodies and institutions. And I believe one of the ways for a holistic and comprehensive resolution to this problem would be prejudicial request institution is to be set up. These procedures would then be handled through national legislation and judicial systems. Thank you very much. Now I'm happy to give the floor to the next speaker of the day. That's Nikolai Kazantsev. He's the lead researcher, Institute of Legislation and Comparative Law under the government of Russia. His talk is entitled "The Procedural Tools of Ensuring Legal Certainty in EAEU Law."
Thank you very much indeed, Kirill, for the opportunity to take the floor. I express my gratitude for the invitation to participate in the conference. Find the conference very interesting. My presentation is dedicated to such issues like quite weird things, as from the point of view we have the procedural section, but we are talking about the legal certainty in the law of the EAEU and then Russian law in general. It's motivated because in the law of the former Soviet Union and the domestic law, nothing is perfect. If we look at the material of the Scientific Council, Expert Council under the Security Council of the Russian Federation that take place, based on the data, approximately 90% of the transactions by the large companies between the Russian companies, they are considered and then concluded by the British, the Dutch law, international law. So it's not incidental, because at present the tools of the foreign legislation is much more clear and providing better security for the transactions, not only protection from the court, protection from the state, impact from protection from each other. So it's of fundamental importance. But to make sure that any principle is implemented, is used, followed, is not sufficient to use the material law principles, because the principle of law are executed through the process. And here the procedural details that I would be coming back to them might not be useful and helpful for the future. So, in essence, the principle of legal certainty, even though it widely included into the constitutional practice, I'm not going to repeat my thesis, and I'm simply referring to kind of citations, couple of citations, because this principle is sometimes used in the wrong way. Say, for example, Kulakova writes, as legal certainty turns from the point of view of protection of interest and legitimacy. So it's justifying the passive nature of activity of actions of the judges. Or Kisilyov states, Russian courts of general jurisdiction quite easily adopted this principle to justify the refusal to consider appeals and consideration of the cases in essence. So it's known resolution of the European Court of Human Rights, Burmarescu versus Romania case 1999, has kind of a red line for us, and then Gadzhiev, judge of the Constitutional Court, has wrote, following the ignoring the principle became impossible, because Harris, Boyle and Warbrick, if you know the work of these individuals, specifically separated and then kind of structure generating procedure. If you look at this principle against this essence, one could see theoretical statements, theoretical approach. This or that way, they cause doubt in application of this principle. So they generate binary system of parallel system, like binary weapons, so that legal certainty is added, is complemented with the legal uncertainty. So people conduct conferences dedicated to the topic. Uncertainty of the law can exist, but not necessarily through uncertainty, but through common wording of the provisions. The jurisdiction of the law arises, and then sustainable state arises. So if we speak about uncertainty of the law and putting together with a certain abstract nature of the wording is absolutely wrong. However, we may take a look. This known scientist, I'm referring to his name, specific provisions of decisions of the Court of the Human Rights, that is the right for fair consideration of the court is considered by the convention provisions, that is which is proclaiming the rule of the law of the contracting parties. One aspect would be principle of legal certainty. That requires, inter alia, that in the course of final consideration of the case, the decisions or verdicts have never caused doubts. And then legal certainty envisages respect to the principle of re judicat, about the inadmissibility of the case once considered. And then they arrive at a conclusion which is quite strange. However, the European Court of Human Rights opinion is debatable because it's not quite certain, and then may not have major aspects. The referred acts of the European Court of Human Rights, the court did not bother to develop their own concept of the rule of law. And then this scientist continues, presume that at present the doctrine of the rule of law adopted, recognized by the majority of specialists in the sphere of law is of practical nature in general, and in Russia in particular, has not taken shape. And then is accusing the European Court. So accordingly, they have developed the principle of legal certainty, in essence, in turn acted as the legal legislative body getting outside of the scope of its competence. It is appropriate to say, voice, which is the objective of the respected professor when he is using the eloquency, trying to refer lack of competence of the European Court of Human Rights, and it's following the principle of legal certainty in the system of internationally recognized legal principles, linking legal certainty with the rule of law and the rule of fair consideration by the court. Certainly, in the Russian literature, there is objection to this kind of approach, even though this is widely used in the book of certainty and uncertainty as parallel category, binary category, to 12 international conference materials in the Russian State University of Justice. From my point of view, it would be more appropriate, and then relying Marshakova work, which is underlining the standards of certainty, was recognized by the European Court of Justice. One of the major principles by European Court comes from the rule of law and the essence of the public law, applied first of all in relation to relations between these individual and public bodies, both authorities, national and supranational, of comprehensive nature, and per se is applied in relation between the states, member of the Union, and its bodies. The Luxembourg court, following the dispute of the individuals, Duff Arvens against the Ministry of Agriculture, and this dispute, this case, determined the essence of the principle of legal certainty is ensuring the predictability of all situations and legal relations regulated by the law of the community. And its essence may be limited to the following: liabilities applied by the state to citizens should be clear, understandable, and then without any doubts all norms in interpretation of the law shall be resolved in the favor of citizens. Well, this issue is very important at present because I'm coming back to the economic issues, literally for 1 minute or a couple of seconds, because I do have just a degree in economics, PhD in economics, but as chairperson of the accounting chamber, Kudrin, Chamber of Audits. In Russia, the rates of economic growth is below 1%. Taking the floor in economics, School of Economics, it's even the stalemate that was typical for the Brezhnev era in the Soviet days. So the question that there is a law, there is legislation, and legislation may be as such, so that could cause damage to the economy, national economy, and may not be of legal nature, and the laws may not be of legal nature, is a very serious situation, when only the court could find out the solution of this issue, and the court would have to apply certain active approach. At our Institute of Justice, we have issued a book, Economic Reservations and Economic Troubles of the Law. So we do have issues that are generated by the norms of legislation, rather than which are causing the damage to the national economy. So this is something new. So irrespective of the legal cause or legal evidence, so that's in the Roman times, there were casus missus, so that omitted case in the law. So this phenomena lives in Anglo-Saxon law. Qualify the situation considered by the judge. If he or she sees casus missus, then he would or she would be entitled to interfere and then be active, show active position of the court, the judge, and then exercise justice, replenishing the legal lacuna. So there should be cooperation between the executive and judicial power, so that they become colleagues. They should not be of comprehensive nature. So the court should be independent and to a certain extent standing to defend the law and the right, sometimes even more active than the executive power. It is worth referring to the case that I expressed in my article in the International Justice magazine of number 3, issue 2020. It's the case Limited Liability Company Marian Group versus Russian Federation. Marian Group approached the Eurasian Economic Court because the Eurasian Economic Commission failed to carry out systematic monitoring of respect and compliance with the law. What is interesting, the case that was one of the first to be considered, that legal certainty, Brumarescu versus Romania case, because the first instance court, as in relation to Marian Group, in relation to Brumarescu, has acted in a fair way, decided then, in violation of the principle of res judicata and legal certainty, have been reconsidered by courts of higher instances. In particular, in Marian Group, it was 15th Court of Appeal, then Northern Caucasus Court, and then in the long run, Supreme Court of the Russian Federation. So they were unique in their lack of comprehension of the right established by the law, a treaty by the Eurasian Economic Union. So this right established by the treaty was perfect in relation to the perfect legal certainty principle in the way, so that in essence the right was established and described in the Annex number 6 to Para 6, Part 2, Annex 6 to Treaty of the Eurasian Economic Union. Its essence was that vessels hired by the legal or individual entities, individuals by the member unions, they were marine group vessels, they were not subject to any custom duties. However, neither full understanding of legal perception expressed itself or certainty of legal certainty. So it's not only prescribed and stipulated on paper, there should be in the minds of the lawyers, barristers that are defending interests of the Marian Group, and though in the minds of those who have been considering the case in relation to Marian Group, no one paid attention to the provision that I was just referring to, para 3, point 3 of part 2 of Annex 2, which is establishing the protocol of common customs and tariff regulation. The dispute was the exemption of the customs duties was offered, and the court was fair in protecting interests. But this legal uncertainty that has been arising very often in the minds of people because of wording of the laws or failure to read appropriately the provisions of the agreement, as we might express ourselves in this particular dispute, that was specifically related to the decision of the court on the case of Marian Group. It's interesting from the point of view that the claim was prepared with omissions, with failure to understand the provisions of the law and requirements of the law. Certainly, the principle of legal certainty, to carry out it in a holistic, comprehensive way, one should not describe and stipulate provisions of the law very carefully and carry out and adopt verdicts of the law, of the court. So it needs to make sure that people understand the limits and certainty of the law and be aware when they place or file a claim in the court. In this particular situation, it is worth using the experience when I learned quite a while ago, when I listened to the lectures for judges as part of the mission of the administration of the President of Russia, how the experience is used when they prepare a file claims and applications to the Supreme Council of France, its highest court of the French Republic. State Council of the country has the exceptional rule because none of the law in France adopted by the Parliament is not adopted because prior to the situation when the State Council of the country issues instruction how to apply it. And here at the first stage, procedural stage, when they have been filing applications to the Council of France, if the individual or individual entrepreneur filing this kind of application, then lawyers of the State Council that are specially appointed for these purposes assist individual entrepreneur or small business entity to prepare the claim that would be of the nature and would be aimed against the officials of France. When this is, whatever this may sound strange, how comes that the lawyers and the court agree upon envisaging this kind of process or the pre-trial, or they allow that preparing a claim should be free of charge assisted to individual or small business entity should be assisted in preparing the claim against France. The logic of the Republic is to make sure that the citizen is entitled to protect common good, common interest from illegitimate or incompetent actions or inaction of the officials of the Republic. In this respect, French lawyers believe that they continue the tradition of the ancient Rome. When Actis Popularis has been envisaging that each citizen of Rome is entitled to protect common good in the court against the illegitimate action of any official of the state. And this kind of procedural measure, I would have suggested to consider in the Eurasian Economic Court in order to make sure that we cover a larger group of people that would be entitled to approach the court, offering to consider cases and problems, to avoid situations when the Tarasik claim, when the case was not satisfied, the case was dismissed. When the statistics say that what kind of attempts are taking place, so that the number of cases, the percentage of cases which are not considered or not satisfied, dismissed, 40% of claims are adopted, whereas the applicant does not receive the desirable outcome. And the same percentage is not accepted for consideration. Sorry, we are limited in time. I'm finalizing. What is important to overcome in implementing this procedure is to overcome the state imperial law Mark was referring to. So the national state pushes this national interest. So this is the imperial law is probably worse when they push the interests in the international relations. It is when they impose in illegitimate claims against legitimate, in this particular case, customs benefits, fringes, as it was the case with Marian Group, against the conditions and goods and interests. When the state turns to be the party acting as a fiscal body, acting on the basis of pursuing common interests against private interests. But the economy is the process of private interests, execution, respect, turnover, and implementation. Thank you for your attention. Thanks very much, Nikolai, for the very interesting presentation. From my side, I would note that the topic of legal certainty is indeed very important for the court and found its reflection in many legal acts, both of the EAEU court and the union's courts, in particular advisory opinion based on application of the Ministry of Justice of the Republic of Belarus. It was used for this principle was used, and certainly this principle found its wide application in cases about classification of commodities. I'd like to pay attention that indeed it was interesting that we were able to look and listen to the problem from both sides. For the Commission, that is expressing that need to know the arguments of the party prior to consideration of the case, of the process, and in turn, specific necessity for the parties so that they exercise protection, ensure protection of their rights. And first of all, the court of the EAEU to be able to check and double-check the legitimate nature of decisions of the Commission. That's purely formal justification of the adopting acts. It's not very often sufficient because it's expressed in the sphere of classification of commodities, when the motivation of this or that decision to grade this or that commodity is formal reference to item 1 and 6 of the major principles of interpretation. We do have a little bit delay, so we're outside the schedule. So I apologize to the presenters. We will have to reconsider, so there's move the discussion to the end of the activities of the session. And I'm pleased to offer to take the floor to Vilhelmina Shapshina, partner of Ernst & Young, head of the practice on customs regulation and international trade. Thanks very much indeed for finding the time in your hectic schedule and were able to join us in the meeting.
Thank you, dear Kirill. Indeed, I would like to appreciate the fact that I was invited by the High Court to speak. Particularly, I am a bit sorry because I see how interesting talks have been when you're getting us together and you lock us up in the room, so to speak. It helps a lot. I mean, we can forget for a while our work-related issues. The reason I feel sorry is that I was unable to attend previously. I will watch the recording later on. Let me share my screen now, and I hope it's online. Yes, yes, we can see it. And we've discussed this with the organizers before the event. We decided to give this topic a spin, the legal mechanisms for cooperation between foreign trade operators and the Eurasian Economic Commission, the monitoring function. It became part of our section. The emphasis will be put on the monitoring function. Right, so I have shown this first slide on the procedures. However, well, I might as well skip to the next one just to save time, because there was a very good talk by Olga before. She specifically dealt with all the pretrial settlement procedures and pretrial procedures at large. Indeed, the consideration of any matters related to the implementation of the treaty, I mean the treaty on the EAEU and international treaties that EAEU abides by, and the decision of the bodies of the EAEU, they rest within the exclusive competence of the court of the Eurasian Economic Union. This pretrial settlement procedure was outlined in very much detail by Ms. Kadышeva. Indeed, this is a way to present cases to court, before the court, actually, before it even appears in court. Essentially, the legal regulation of the procedure how claimants can appeal to the Eurasian Economic Commission, we can initiate such appeal only if formally and legally, and in this respect, I enjoyed Alexander Naumov's presentation. It was very relevant. Thank you for bringing this to our attention. So, to implement this so-called pre-trial stage, we are supposed to find a very appropriate match of the subject that we bring to, that we debate about, some incompliance, some action or alleged action or omission by the Eurasian Economic Commission, and subsequent court case that follows. We're supposed to demonstrate the violation of legitimate rights and interests of a person in entrepreneurial or other type of economic activity. Everything is very specific. And yes, it's not about whether there is life on Mars, or as Alexander put forward, or what kind of actions should be taken in case of an alien invasion. So we are very specific in this respect. If we're looking at existing regulations, regulatory framework, the provisions of the treaty on the EAEU and the decision number 46 of the Eurasian Economic Commission, they do not directly determine the right of foreign economic activity operators to initiate the monitoring of legislation. There is no such thing. However, in 2014, the appeals chamber of the EAEU court has determined that the foreign economic activity operators are entitled to trigger monitoring by the EEC in case their private interest has been infringed. That's the first statement. The second statement is, alongside that, the foreign economic activity operator, they must bring proof substantiating the instance or proving that their rights and legitimate interests have been infringed. So this is a model pathway, the way I see it, the pathway of implementing monitoring and overseeing the implementation of international treaties that the EAEU member states are supposed to be complying with. As the Court of Appeals has said, I'm sorry, I've unshared my screen. Give me a second, I'll get back to the slide deck. Just bear with me for a second, my slides are gone temporarily. I'll just bring back the slides and just bear with me for a couple seconds. Right, so the slides are on. As the Chamber of Appeals, as the Appeals Chamber postulated, the outcome of this monitoring would be the constatation of the fact that there has been due performance of the obligations, or there was an instance of violation of these obligations by an economic operator. So there are no clear-cut provisions here that would say, was that would cause us to follow, well, jurisdictionally, I mean, from the viewpoint of the procedure. Because on the one hand, this could be the adoption of an opinion or recommendation at the level of the Eurasian Economic Commission, or at the same time, I mean, in a number of cases, sort of a consolidated decision is passed. In a number of cases, we proceed according to this upper pathway. We notify the member states of their obligation to perform or obligation to comply with particular legal norms, the incompliance of which has been found by the appropriate entity because of the, as per the outcomes of the monitoring by the EEC. I also serve in another capacity. I'm a legal advisor, other than stated in the agenda. So in our practice, we maintain this overarching concept, the protection of rights of businesses, where any visit to court is deemed or is considered to be the last resort, the ultimate measure, the ultimate option to resolve a dispute. In my experience in the taxation bodies, in the customs bodies, in my law practice, I proceeded from the fact that whenever there is a possibility of dialogue, the dialogue option should be grabbed on, made use of, to avoid going to court. Subjectively, I believe it's more efficient, as the practice suggests, as my experience suggests. And also, cost-wise, the costs borne by businesses when they implement that or another right through court are much higher. talking about particular ways or specific ways to enhance the current procedures or the legal mechanism, even compared to national, to domestic institutions, this monitoring function is very actively discussed. And not just that, it's not only discussed as a tool for interaction between the state and businesses. It's also fully, well, at least in the Russian Federation, it is also fully and actively implemented. I participate in this as an expert. Foreign economic activity regulation, customs regulation. We talk to ombudsman for the protection of the rights of business entities in Russia. I believe there is a clear way to enhance the supranational legislation, supranational regulation mechanisms, because definitely foreign economic activity entities are interested in resolving a number of ambiguous issues. First of all, it's dealing with conflicts in the national acts, national pieces of legislation, with the international legislation. Let me give you a clear example, a vivid example that the members of the EAEU, the members of the EEC know full well. The dividends of the customs cost, customs value of the goods. This arises from the interpretation of some provisions of the customs code of the Eurasian Economic Union. And having performed a certain expert review, expert evaluation, we see a clear contradiction of that with the norms of international law. More specifically, these norms of the EAEU customs code were based, the way I see it, on having some international law provisions translation. We saw that this translation is unofficial, and there is a horde of mistakes. How do I put it? Yes, a horde of translation mistakes. This very fact leads us to conclude that such provision in its translated form is invalid, and it's not matching, not compliant with the with international law. This intersects with the third bit of my presentation, the part that is sensitive for businesses, because if there are any manipulations with the customs value of the goods, they can change the value, or they can change the amounts of customs payments, which in the current economic realities is completely not benefiting the economic operators. The same goes for the classification-related issues. When we identify a difference in approach between various member states as to how they classify or categorize specific goods. In this case, it's very difficult for us to find the reason, having shown that the Kazakh decision or the decision taken in Kazakhstan somehow infringes the rights and interests of the Russian economic operator. Well, the Russian Federation is proceeding from different approaches. I believe that this thing, the customs value of the goods and classification of the goods, are two particularly important, are two critical domains that require standing, ongoing monitoring and classification. Protection of intellectual property objects, intellectual property items. We do not maintain a unified customs registrar of such, of intellectual property rights. I will not dwell too deep into examples, but there is a clear difference in approach to this. Basically, the IP rights are not homogeneously recorded. Technical regulation is the fifth domain where countries again fall short of homogeneous approach. They handle this technical regulation differently. Summarizing these points, I would like to say that first, we realize that because of this filling the gaps, filling the lacunes.
как сказать, право на вот эту инициативу в проведении мониторинга апелляционный суд
When the
вынес
appeals chamber is engaging in monitoring and passes the judgments. However, in practice, the foreign economic activity entities are finding it very hard to show abundant proof or considerable proof, significant proof of their interests and legitimate rights infringed. I believe that we should, this fact, the inability of economic operators to prove the violation of their individual rights and legitimate interests at all times, this fact alone should not prevent the EEC from triggering the monitoring and oversight of the EAEU law. Whenever we talk about various judicial procedures, again, if we go back to the roots of state governance, we will remember that one of the core principles is the minimization of state resource, or state administrative resource. There must be a more proactive approach by the EEC, giving the businesses an opportunity to trigger monitoring. It would, in a way, relieve some of the workload of the Eurasian Court. Thank you very much indeed. This is everything I had to report to this distinguished audience. Should there be any questions, I will be happy to take them.
Вильгельмина Прановна, большое спасибо за очень интересное.
Thanks very much indeed for the interesting presentation, Vilhelmina. Indeed, the interesting idea about improvement and perfection of the legal mechanism of monitoring. Now, I'd like to offer the floor to our next presenter, the Moscow State University postgraduate student, Sofia Pimenova. The floor is yours. Very good afternoon. Respected colleagues, I hope that you hear me lima Charlie. If not, notify me. So, first of all, emergence of the Court of the Eurasian Economic Community. Sorry. The emergence of the Court of the Eurasian Economic Community and the EAEU Court that replaced it caused a wave of interest to issues of Eurasian justice. At the same time, all these studies did not touch the issue of application of interim measures or just security measures in the Court of Eurasian Integration, even though, as the current practice of international courts shows, the role of such measures in activities of any court tend to be increasing and the key to the efficiency in work, in activity. It is worth noting that the reasons why international courts resorted to interim measures are in many ways very similar to the goals pursued by national courts when these measures are applied. Any litigation, when we speak about the international level especially, it requires time, as the persons involved may change their situation and in the most radical and irrevocable way. If actions that become subject of law may change, which may turn in non-execution and basically inefficiencies of the decision that was subsequently taken on the merit of the case. In case of the EU Court of Justice, as the institution closest in its objectives to the Court of Eurasian Integration, the measures taken as interim measures are of universal nature that are common to both international and national courts. That is, auxiliary nature of the proceedings in relation to main aspects of dispute. Focus aimed at preserving the position of the parties to the dispute before the final decision is taken, as well the obvious nature of urgency of application in order to avoid impacting serious or irreparable damage. Well, the EU court itself believes that interim measures should be applied only in exceptional cases, especially when we speak about Commission's cases or claims against states. In this respect, EU court has set high threshold or limits for the applicant to prove the existence of conditions, so that the EU court decides to apply these interim measures. Well, the claim should be a reasonable chance of success, means urgency, and the risk of serious and irreparable damage to be impacted on the applicant must exist. In addition, the judge that examines the application of interim measures should take into account the interests of other parties, that is, to consider or weigh the interests of the stakeholders. What refers the issue of legal nature or legal force of interim measures that EU Court of Justice would take, then regulation of Article 91 directly specifies that it's of binding nature or compulsory nature. Switching to courts of Eurasian integration, I would say, unlike Economic Court of the CIS, the Eurasian Economic Court, the application of interim measures was regulated by 4 documents immediately. In each of them, there was a specific approach. The problem is the practice of the Eurasian Economic Court has never been requested by applicants per se. The court itself believed that resorting to this kind of measures following its own initiative, although they are entitled by the documents of the court, would have been too risky on their part. The result of such approach resulted in absence of any such practice of the Eurasian Economic Court in application of interim measures. It is interesting, so I would note that irrespective of cautiousness of the Eurasian Economic Court, in the regulation there was no reference of interim measures to be applied. At the same time, it is believed that it doesn't mean that this kind of petition or cannot be followed or filed by the party to the dispute, as well as this petition cannot be satisfied by the court, because rules of the court ensure the right of the party to file any petition that should be considered by the court. I mean, one may arrive to the conclusion that the regulation does not prohibit to file using or application of interim measures in a particular case. So, the petition of the interim measures would be feasible to file in the economic entities against the Commission in relation to the law of the Union, and in the interstate disputes between the members of the Union. Probably the only limitation directly envisages is in Article 56 of the statute. That's saying that applications in violation of the treaty in the Union or decision of the Commission is not the ground to suspend such international agreement or treaty or its individual provisions, except cases that are specifically or expressly provided by the treaty of the agreement. At the same time, certain silence or lacuna in the statute of the court that was agreed by the member states should not be interpreted as complete banning on application of interim measures. Because if the states, the countries, wanted to prohibit this kind of measures, they could have done it in an obvious manner, as in the case that is indicated in Article or paragraph 61, that is banning the court from considering claims or damages or other properly based claims. So, silence of the statute means that within the framework of interstate claims or disputes, the parties may apply to any interim measures. The same is applicable to the claims against the Commission, where the onset of serious or irreparable damage can be avoided by suspending the EEC Act that is contested, but by urgent adoption of other measures, for example, banning the state authorities of the member states to apply the EEC Act that is challenged in relation to the applicant. That in no way is tantamount to suspension of its application or action. What is difficult is to justify the right of the court to apply interim measures in case or take into account such powers are not provided in any court documents. Here, to justify this decision, the applied or implied powers doctrine should be used. One may note at international practice and doctrine, there is a well-established opinion that the right to apply interim measures should be considered as implied one or implied right of any judicial body, whether this is international or national court. For the EAEU court, the way they recognize their right to take decision on application of interim measures would be undoubtedly teleological interpretation of the statute, because there is no provision that should be interpreted. In addition, the extra argument to justify the right to apply such measures may be the prohibition or the ban of the court to consider claim for reinstatement of damages. So that means that decision-taking would not be sustainable to compensate the damage suffered by the applicant unless interim measures are taken. No doubt, the EAEU court should wait for such a case where circumstances would be that obvious, so no one would have any doubts about the justification of the measures taken, as well as the existence of the risk that is irreparable to the damage irreparable to the applicant. Notoriously known case of Lagrand, which is considered by the International Court. After years of silence, they have decisive step and declare the necessity of interim measures in the case of capital punishment that was widely elucidated in the mass media. Winding up, at present, the EAEU court, in a theoretic manner, can formulate the thesis about this kind of implied right to apply interim measures, as well possible criteria of application of such measures. So any petition is appropriate, even though it's obviously doomed to be refused. Say, a petition to suspend the EEC decision, which is banned by the statute, as I mentioned already. This would provide an opportunity, a unique situation to express itself on this issue, on the matter, in its reasoning part. When they refuse or turn down the claim, therefore they would lay the foundation for further actions in this respect. As I believe this would be exactly the case when judicial activism would prove to be quite appropriate and to the place. Thanks very much for your attention. That's all I wanted to say.
Софья Дмитриевна, большое вам спасибо.
Thanks very much indeed, Sofia. We indeed have faced a situation when the procedural documents of the court, not only the regulation and the statute, were quite considerably amended compared to the court of the EAEU. Many instruments and tools and institutions that existed then, but which were never approached, they have been simply eliminated. By the way, we speak about specific types of cases as prejudicial requests that they were not used, or the existing right of the Commission of the to apply to court or to file a case about failure to comply with the obligations of the member states. And then the same destiny was procedural mechanism. So it was very interesting to listen to nice presentation about the opportunity to justify the concept of implied powers, irrespective of some lack in the regulation of these measures to be adopted. Now, I'm very happy to give the floor to my colleague, Maxim Shmelov, that were pleased to hear in the conference of the court in 2018, even though in a different quality, So Maxim, the floor is yours. Thank you, Kirill. Indeed, and I'm very pleased to attend the conference in different quality and wearing different hat, acting as speaker from another organization. So I was taking the floor, speaking about the similar topics, implementation of court decisions. So it was resolution of the WTO. So then I represented the WTO. At present, I'm working in the court, and I was able to face the issues of implementation or respect and compliance with the decisions of the EAEU court. Practice of consideration of filing the petitions of cases of implementation that we're going to talk about. International courts and quasi-judicial bodies are really having full competence to inform their own decisions. The governments and international organizations that are sovereign subjects of international law very often endowed with the wide discretion in choosing the forms, methods, and the terms of implementing of such decisions of such instances. The powers of international judicial and quasi-judicial bodies is very often formulated on the basis of the need, based on the decision to refer to inconsistency of the measure into the specific provisions of the treaty or the decision of the instance, the mechanism of which is not clarified. It's at discretion of the state or international organization participant to such treaties, even though it's envisaged specific ways of control over implementation of such execution of such decisions. So this is compliance or incompliance with this measure. Say, for example, the statute of the EAEU court that is envisaging the court's competence to resolve interstate, intergovernmental disputes between the member, again, disputes against the Eurasian Economic Commission, offers the court with a quite limited set of tools that is aimed at ensuring the defendant's compliance with their decisions. We talked about interim measures. So indirectly it's not envisaged, so the little measure to suspend the implementation. So there's a specific norm that is regulating the issue of execution. A number of such norms. Article or clause 111 of the statute envisages that decision of the EEC that is recognized by the court as is consistent or incompliant with the court should be made compliant. Article clause 113 makes the Commission to comply with the decision of the court that action or inaction was considered failure to comply with decision. So their understanding of alignment to enforcement is not covered in the text. Article 103 directly establishes that the parties of the dispute independently determine the form and method of execution of the decision of the court. The statute as well envisages the right of the side of the party or economic entity or the member state to approach the court or higher bodies of the EAEU, the Council, in case the decision is not executed. So it's para 114 and 115. The wording of the statute, as they are containing there, so they're more classical to international agreements that are concluded between the states. And then envisages the resolution of disputes between the states, not touching the consideration of cases between the private individuals or governing body. What I mean is similar norms that decisions of instances should be executed, implemented by making the compliance with. They are more related when participation of individuals is not regulated at all. So there's procedure of WTO resolution of disputes, Article 19.1, rules of resolution of disputes in the free trade area treaty of the CIS, association agreement between the EU and third countries, like the case of Ukraine, for example. Similar wording is there. So decision of certain instance, if the party acted against the provision of the agreement, makes sure that they are made compliant with. The court instances, which are supposed to make sure there's stable, where state, private individuals are involved, say, for example, Andean Community, European Union, EFTA, where private individuals are able to approach the court to consider legitimate nature of court decision. This kind of instances, they have the competence to repeal or nullify if they violate the rights of individuals. Revocation of such act, in case decision of this instance, is normally the execution of such court decision. No additional method of execution exists. Revocation or cancellation is sufficient, that the court decision is executed because the EAEU court is not envisaged of this kind of opportunity. Statute does not envisage this opportunity. In this respect, the court is kind of special sui generis case. In such capacity, that would face certain issues or problems. In my presentation, I would touch upon only the issues of disputes about the actions of the Commission. We are not going to touch about the disputes between the states. The court practice, when the inaction and decisions of the Commission were found inconsistent or incompliant with the treaty. In two cases, economic entities that applied the court and won the dispute believed or considered that the Commission's decisions were not implemented and took advantage of the right to approach the court with petition taking measures to be executed. In both cases, the court refused or turned down such requests. Petitions or applications, according to Article 115 of the statute, provided for Supreme Council to take measures, or decision rather, on the issue of execution of the court's decision. In these cases that were turned down, we will be talking about them at a later stage. These are the cases of Oil Marine Group and ship trade cases. In the case of Oil Marine Group, the court refused to take decision in favor of the claimant. The enforcement of the new customs code changed the actual situation and excluded the non-homogeneous or non-uniform application of the norm that was the ground of the claimant's statement. The court believed that the applicant failed to provide evidence that Commission failed to take into account the position, and the court did not directly evaluate the execution of the decision that was taken by the court. In case of ship trade, the court was aware of the result of the Commission changing the classification decision that was found to be inconsistent with the treaty. The Commission amended it by deleting certain elements of the text. Leaving the question of the essence of the changes, the court, following the request, ruled that the contested decision was subject to change based on the Article 22 of the Customs Code. In this respect, in the opinion of the court, Chamber of the EAC changed and taken such decision pursuant to judgment of the court. In these cases, in both cases, the court referred to the formula that is regulated paragraph by paragraph 103 of the statute, exactly when the parties to the dispute independently determine the form and method of execution of the court decision. However, one would ask a question whether it is feasible to think about limits of the control that the court is able to execute in implementation of the decision. whether clause 03 means that the party will have to independently choose the form and method of execution, because they might have unlimited discretion in such kind of choices. Or one should pay attention to the qualifying circumstances contained in part 1 of the rule. So such norms and ways are chosen without prejudice to provisions of 111 and 113 that stipulates that the court decision should be implemented. The current practice doesn't give any answers. We don't know how this would be developed, in which way. At the same time, it is worth how other international courts approach to monitoring as their decisions are being executed. Possibly that might be helpful in case of implementation of decisions in the future, irrespective of the form, whether they would be considered as executive procedure according to Article 115, or as disputes of the appealing against the inaction or new decisions of the Commission. Whatever is taken, that the court has to develop certain criteria in consideration of such cases. In this context, we would like to point the practice of other bodies and their approach to monitor execution of their own decision taken. Perception of the legal force of the bodies is common to a number of legal systems. A product of the legal force of the decisions is the issue of the obligation and enforceability. Decision taken is binding on parties and should be executed, which is the consequence of the rule of law and sustainability of the court decisions. Enforceability, as element of the content of the legal force of court decision, ensures that it is stable, whether this is voluntary or compulsory implementation of the imperative instructions that are contained in the court decisions, because this is opinion of the doctrine. However, how the control is exercised in public legal relations is controversial and comprehensive, complex, because enforcement in decision application is, as a rule, non-typical to public legal relations, because a binding nature is not arising from the opportunity to push, but the rule of law per se. In addition, the principle of separation or division of powers is in effect, because one branch of the power is not entitled to interfere, because the court cannot replace executive power, whereas executive power is unable to replace the competition of court. So they are unable to invade in the competence of one another. As international law is concerned, it is important to mention the principle of conscientious implementation. So, binding nature of implementation is closely related with good faith in fulfillment of international legal obligations in general. And then, good faith fulfillment cannot be considered when they formally execute, because actione bona fide and then actions of formal legal nature, actiones stricti juris. The permanent chamber of international justice, when they adopted advisory opinions 1932 and 1935, which is basis of the public rule, rejected as formal implementation of the court if this was violating the spirit of the treaty. This kind of understanding could be applicable not only to the decision, but to the treaty. Practice of international courts, the permanent appeal of Mercosur, in the case 1/2008, looked at the issue of Argentina execution, decision on Uruguay case. Argentina cannot change the law based on the new legal text on the basis of the same provisions that were rejected or turned down by the court. Otherwise, it would have been meant the decision could be enforced by simple amending of the law, whereas the substance of the situation would have remained the same. So Mercosur court stated that purely formal approach to execution of the court decisions is not sufficient to make sure that it's bona fide implementation. What kind of other criteria courts are guided when assessing the execution? Let's look at the practice of Court of Justice of the Union. it is necessary to say that EU is a specific case, then there is no procedure to enforce. However, there is a procedure, quite long-term practice and sustainable practice to approach the Court of the EU with issues of inaction of the Commission related to implementation or execution of the court decision. In this respect, they have worded certain criteria, the way the court considers whether the Commission was active or inactive, Asteri's case, so that make sure that the decision is fully implemented. The EU body should approach not only the resolutive part, but also the grounds that resulted in decision, and it's part and parcel of which they are necessary in order to make sure that unequivocally to determine the resolutive part. These elements determine specific situation when it's considered illegitimate, and they refer to specific reasons where a decision is taken that it's of illegitimate nature, and then the appropriate body should take into account replacing the annulled measures with a new tool. The practice of such cases being considered in a very brief manner was generalized by the Shabstan, Islamic Republic of Iran shipping lines, where the lawyer noted that according to the sustainable practice, the body that acts is being repealed should refrain from identical measures. B, should ensure that any act adopted in order to replace the illegitimate and nullified act does not contain the same shortcomings that were established by the court in taking the decision to annul the act. C, should ensure that new regulation adopted by decision of the court should not contain provisions that are of the same effect that were found to be illegitimate or illegal. That's what concerns the practice of the EU court. It is interesting to look at the practice of WTO bodies that are resolving the disputes. There is a requirement to set the measure appropriate that is considered inappropriate or incompliant. Even though interstate mechanism of quasi-judicial mechanism as WTO indeed evidences that parties to the dispute have discretion in choosing the form and method, but it's not limited. It's not unlimited. The practice of resolving disputes, the following established. Indeed, for example, in depriving the EU the subsidy for sugar export, the arbiter decided that is implementing measure, executing member doesn't have an unrestricted right to choose any mode of implementation. So they should comply with obligations of the WTO member. This kind of method should be as such to lead to implementation of the decision in an appropriately reasonable period of time. Then Colombia, ports of entry. That said, irrespective that implementing member of the WTO has discretion to choose the method of performance, it's not restricted to choose any mode of implementation. Implementation decision and recommendation of the dispute resolution, the arbitrator stated that it should be appropriate to form, nature and content to make sure that alignment with the appropriate decision and per se should be consistent with the agreements within the WTO adopted. To summarize, even such system as the WTO law, the issues of implementation or execution does not offer unrestricted discretion by the member states or implementing authority. Very shortly, I would like to refer to the constitutional control bodies, because in certain integration bodies they considered as certain similar to constitutional control bodies, implementing a similar function because they evaluate the legitimate nature of with a certain constitutive act associated. In this respect, is interesting the Russian Federation practice. In one of the definition, they expressed which way its decision should have been implemented. They stated the following: all regulatory provisions similar to that norm that is not in compliance to the Constitution of the Russian Federation was recognized as invalid and not subject to application also should not be applied to any legal system of the Russian Federation constituencies. Legislative and executive of the state power are not entitled to adopt any acts or take actions or being inactive aimed at maintaining these provisions in the legal system, in the legal regulation and enforcement of the law. An important conclusion based on the practice of judicial and quasi-judicial bodies is the decision which decisions were considered illegitimate and the discretion to choose the form and method of implementation. It does not prevent the court and quasi-judicial board to have form of control. It is stipulated the discretion is wide. It's limited to a certain by certain principles. In a brief manner, I would speak what kind of criteria could have been stipulated by and evaluating the implementation Eurasian Economic Union Court. I would have selected and voiced 5 criteria like this. First of all, whether they have taken into account the content, not only resolutive part, operative part, whether the act or action taken contains the same shortcomings that were recognized illegal or incompliant, whether this act adopted is aimed at maintaining provisions that were found inconsistent or inappliant in the legal systems of the Union, whether they result in their being maintained, irrespective they were considered incompliant in the application of law. 4. Whether the adoption of act or taking action results in change of legal status of the plaintiff and restores its rights and legitimate interests that were violated by the decision that is contested, and whether judgment of the court complies with the principle of good faith and it's not merely formal, as I mentioned. Irrespective of the practice, irrespective of the forms that whether there would be petition or new decisions, it seems that such criteria could have taken into account based on the practice that we have analyzed. Thank you for your attention.
Thank you so much, Maxim. Indeed, we've had a very interesting section, a full-fledged section, the full cycle. We started from pre-trial settlement and ended, or talked through all the way through the implementation or enforcement of judgments. We've discussed such points as the possibility for the court of the Eurasian Economic Union to take provisional actions, or to take enforcement action. So in this respect, I wish to voice one question that came to our Telegram channel. It's Anna Malashkova, PhD in law. She's advisor to a judge of the Eurasian Economic Court. She would like to ask Sofia, the judge of the EAEU Court. That's about the integration. Particularly, she's asking about the practice of the Eurasian Economic Court that acted as the Eurosec court until recently. And the positions voiced by the court under the petition of Belarus for the preliminary measures dating back to 2010. So please, Sofia, if you could answer that question. Yes, thank you. One thing I can say here is indeed there has been such a case about the provisional measures. However, about the provisional remedy or injunction, Unfortunately, the court turned it down. The sound is coming through. The sound is coming.
Софья, продолжайте, мы вас слышим.
Please go on, Sophia. We do hear you.
Так, ну еще раз повторю, да,
Right. So just to reiterate, there was a request for injunction.
Да, то есть было
The court
без удовлетворения ходатайства.
turned it down. That petition was quashed.
Сказал, что
And essentially,
вот этот запрет,
the court said that this ban on charging customs duties on petroleum products shipped from Russia to Belarus is not among such measures, is not a provisional remedy, because the use of provisional remedies would have meant substantive consideration or consideration of the case in essence. On top of that, the substantiation of the said remedy, it lacked documentary proof. That's it. Yes, thank you, Sophia, for this comment. There's another question I would like to voice. It also came from an advisor to the expert and analytical section of the court. This question goes to Olga as well as Nikolai. In your perspective, what are the prospects of the formation of the legal determination? You have mentioned that legal certainty is an issue at the pretrial stage. However, the Court of the EAEU has emphasized the principle of legal certainty and adherence thereto in its practice. If you wish to comment, please take the floor. You know, it's more of Nikolai's topic. He dwelled on it more in his talk. In my presentation, I merely sought to show that following the pretrial procedure will implement fully the principle of legal certainty. And in this case, I believe that the court is moving in the right direction. I see no serious challenges along that path. The whole point is to provide for all the procedures codified by the statute of the Union Court, implement them into real life, basically. Whereas the principle of legal certainty, well, it's always there in what the court does, and it's quite clearly identified in this activity. Nikolai, would you like to comment? Yes, thank you for the question. Indeed, I've paid attention to that aspect of legal certainty that was not considered before. Now, legal certainty of legal forms and norms in the heads of the people, particularly those engaged in law enforcement, as well as the citizens who use law for their economy and for the development of the country. I've put forward one of the many recipes, many possible recipes to ensure this legal certainty prevails in the heads of people. But, well, this recipe might as well, or should as well be tried, although I realize that you don't have a lawyer's staff in your court. The French practice is almost 200 years old, 2 centuries old. It's wonderful. They've created administrative law that's traveled pretty much across the world. What was borrowed across the world, including partially, at least for now, by Russia. I believe that this method whereby the citizens can control the powers of the officials and the notion of administrative law in France is defined as such, is the right vested upon the citizens to control the officials through courts, which is contradictory to our notion of administrative law. I believe this path can be taken by the court of the Eurasian Economic Union and possibly by Russian courts as well. However, seeing the elite nature, or particular elite nature of the judges in the Eurasian court, I believe you'll be able to be of help. Of course, given that you receive the manpower and the staff, basically. Because the current composition of the EEC, well, there's a similar balance between the judicial and executive power. This balance is insignificant. So if this develops, then legal certainty will prevail in the heads of people. Thank you so much for this comment of yours. Indeed, if we were to compare our head count, our staff numbers with the Court of Justice of the European Union, where, well, many more people are employed, about 2,000 people. More than half of the Court of Justice of the European Union are interpreters, linguists, and lawyers, professional translators and interpreters. The Court of Justice of the EU is a kind of a Tower of Babylon, with all those possible language combinations, with the possibility of sides to the dispute to use their native language, which ensures or grants access of the parties to justice, but it complicates the life and the day-to-day operation of the judicial body itself. I'm also happy to give the floor back to Olga for a small comment. Kirill, thank you so much. I just wanted to make a small caveat, a counter comment to your comment. With respect to individuals, we cannot put an equal sign between individuals and states, countries. We cannot fully apply the provisions of Article 43 of the statute to individuals. But what we should rule out in our heads is finding some difference in the court of the Eurasian Union. If the statute establishes the right for individuals, and it's not just individuals at this point, it's economic operators, it's individuals of a different nature rather than pure natural persons. I believe that all the sides to disputes, economic operators, Eurasian Economic Commission, the states, member-states, they must enjoy equal footing, or they must be on equal footing. They must enjoy equal rights. Thank you so much for your comments. Hopefully we'll be able to continue this discussion in the future, and we will see what the practice of the court looks like in this domain. Definitely, Olga, I wholeheartedly agree with you. This is indeed the case. If the norm has been codified in the regulation or in the statute, we're supposed to apply it uniformly, or following the uniform approach. What I did point out was the standard. Which standard are we supposed to proceed from when interpreting this norm? Are we supposed to proceed from the high standard developed by the Court of Justice of the UN, International Court of Justice, or we could proceed from other criteria, particularly from recognizing the fact that for economic operators, the key criterion for admissibility is the criterion of having their rights and interests infringed in economic or in entrepreneurial or other types of economic activities. This is indeed a subject for discussion. At this point, I wish to thank all our presenters for the talks they've delivered. Just a reminder, we'll be happy to publish your articles, or at least your talking points, in the directory or in the compilation of the materials summarizing the conference. Thank you very much indeed, all of you. This is a reminder to our audience that our conference will resume tomorrow at 10:00 Minsk time. So we're looking forward to yet another interesting section dedicated to matters of competition right, or competition law, particularly competition in the Eurasian Economic Union, with a wonderful selection of speakers. That section will be moderated by Judge Kolas. I wish to thank all of those tuning in. Until we see each other, all the best. Thank you. It's been a pleasure.